Hey everyone, happy Thursday. Thank you so much, Holly. I really appreciate that. Thank you so much for always gifting memberships. It means a lot to me. Thank you. I appreciate you all being here. If you haven't, please hit the thumbs up. I'm going to do this in several ways today, but I'm going to go ahead and start with this. Let's educate. Let's educate.
SLAPP stands for Strategic Lawsuits Against Public Participation. These are lawsuits which utilize the legal system to intimidate, censor, silence, and harass critics or opponents. Simply speaking, SLAPP suits are a form of legal bullying. The most vulnerable to SLAPP suits include human rights defenders, political activists, victims of violations, communities affected by development projects, academics, but it really could be anyone expressing their views. Ever used social media? You could get slapped. SLAPP suits infringe primarily on the rights of freedom of expression and the freedom of assembly and association. They shrink space for healthy discussion, dissent, and debate among civil society. That's you, by the way. Thinking strategically, plaintiffs commonly file cases in districts far away from the defendant's location, bring multiple cases against defendants, or drag cases in court, increasing financial and emotional strain. The resulting burden on defendants is immense, and yet SLAPP suits can start from just a single tweet. It's the big guy versus the little guy, but it doesn't have to be that way.
Just start you off with a little bit of education. It can start with a tweet. It absolutely can. And that is exactly what we have witnessed happen here. So there's a few things that I want to go over today. And of course, the transcripts being one, but I also want to read you or show you all some of this. So both of our attorneys, my attorney, Miss Jess, welcome. Thank you so much, Feisty Nana, for the 5 gifted memberships. Thank you. No, we didn't win, Captain Kurt. Not yet. I do appreciate the thought. Miss Jess, thank you so much. Give me one quick second. So I'm going to read you. We went ahead and submitted a few documents. One being a supplemental reply memorandum of law in support to the motion to dismiss. And if I can get this thing to open. On here, we do have exhibits. So I know they said they had closed exhibits, but that's not necessarily true. Give me one second. Pull this one up. Oh, why is going this way? Hold on. My attorney submitted 8 exhibits. How do I? Okay. So I'm going to start with this. I'm going to start with the latest movement because that's what's happening. And then we will get into the transcripts in just a minute. TT, thank you for coming in, hitting a thumbs up. Hey, Shell. So we went ahead and we did a supplemental reply to memorandum of law in support of my motion to dismiss. And it basically just tells you everything you need to hear, right? It gives you the backstory, which is October 18th. They filed this, la-di-da. So I'll spare all of that. I think we've heard all of that a million times. But basically is asking, the question presented, should this be dismissed? The answer, yes. And he goes into why. So first will be the supplemental fact that the reply to argument. This is solely based on the Rico, which is the most ridiculous, in my opinion. Good morning, Candalee. Hey, Aidas. So I'll be on a different screen, so I won't be looking at the chat too much. But there's a few parts of this that I found to be Very interesting. I'm not going to go through it all because there's a lot of like, the legal jargon and all of that. But it basically says they have a lack of standing. And it breaks down why they have a lack of standing, which I think most of us are fully aware of. It goes into how, like, if they claim to suffer a derivative of injury, they have to like show that, and they've never showed any of that. So it says, here we assert no Rico predicate acts have been pled. As a result, this court should end the analysis of this rogue attempt conjured up by plaintiff Hasafrasu to use this court for improper purposes, silencing these two defendants because they do not like their critiques of other content creators on YouTube and the individuals they review. See Exhibit 1 attached here too. These filings are nothing more than an extortion of the voice. And then I'm going to show you guys the exhibits as I do this. There are a lot of pages here. Okay, hold on. Stand by. I don't know how I... There we go, duplicate. So Exhibit 1 is going to be no other than the law offices of Mr. Lasniak. So that's where he hashtags Sebastian's name and says, make no mistake, the walls didn't just stand firm, they got an upgrade. Turning into a fortress overnight. The dog isn't just hunting, he's the scent. He's on the scent, and now they've come for one of his own. The hunt isn't just on, it's turbocharged. We'll be unveiling our arsenal of resources we intend to bring in the form of legal manpower to elite contractors in an effort to combat webcam warriors and the individuals fueling their hateful rhetoric. Huh? There are elites. Elites. Remember, they keep using this term elites. I love it. These resources will be detailed on television in the coming days with additional lawyers joining the team. Does anyone recall this being televised anywhere but WKRN? Better yet, what other lawyers have joined the team? Have any of you seen any other lawyers? Right, webcam. So outdated. Then he writes, simply put, we are ready and to tackle the webcam warriors and their ringleader with more than just words. Our message is clear. While @Dog and @Nick continue to pursue this case, we will be pursuing every legal remedy available. Well, I'll tell you what, they have came in here in September. We are now into February, and they still have not done anything, in my opinion, substantial to Sebastian's case, but cause a circus. Thank you so much, Kelly, for the Cash App. I really appreciate that. I keep seeing people say, like, oh, poor Sebastian. Look what they're doing to Sebastian. Listen, take that up with his father. Take it up with the alleged and private intelligence group. Take it up with Dog. Take it up with Tony Mathis. Take it up with Betty. Take it up with BJ. Take it up with that TikToker I don't even know. Take it up with Julia. Anyway, going forward. For our purposes, courts consistently hold personal injury and wrongful death actions. Sorry. Again, it breaks down how these people have no injuries, but none of that, that's all exciting, and I appreciate the hard work that went into it. But what's really important is to listen to what's being said over here. So over here we have, as this court can see, the claims of these plaintiffs for emotional distress, defamation, harassment, etc., fail to meet the standard for standing under Rico, regardless of whether they suffered damages, which of course is strictly denied. Most importantly, verbal abuse is not recoverable under Rico, nor is sarcasm. In fact, the Seventh Court held a business competitor harmed by alleged slanderous statements made to his customers did not have standing to assert a Rico claim based on mail fraud. We assert the same in this context. Nothing, neither mail fraud nor wire fraud, was alleged herein. In paragraph 177 of the complaint, the overt acts of racketeering are as follows: defamation, false reports, which has a footnote that says no such false report is attached hereto, cyber harassment and stalking, and conspiracy to disrupt investigations. As stated throughout the supplemental reply memoranda, defamation is not an act of racketeering, nor is cyber harassment. Stalking, or this made-up cause of action of conspiracy to disrupt investigations, with a footnote that says neither the FBI nor the TPI has made any statement about these YouTube content creators who sit at home and comment on true crime interfering with their investigation. If they felt this was the case, certainly the FBI would make such known to these content creators. This case is littered with causes of action asking this court to make a determination on numerous counts alleging violations of criminal statutes, none of which are predicate acts of RICO, nor have a place in a civil forum for redress. Statements made by one content creator on YouTube to their viewers does not confer standing on other content creators' claim to be harmed by alleged slanderous comments, even if true, which is strictly denied under RICO. Now, I'm going to spare you guys a lot more of this, but I'm going to show you. Basically says they suffice in detail to show how this claim enterprise stopped anyone for looking or finding the missing teenager. In fact, it has been asserted that plaintiff Chapman, aka Dog the Bounty Hunter, a claims bounty hunter, has boots on the ground in Tennessee. Clearly, the non-existent enterprise has not stopped plaintiff Chapman's supposed search efforts. Moreover, plaintiff Chapman claimed the search was moving to this county. Anybody remember this? Delco, the fight for an answer about little Sebastian's disappearance is now moving from Tennessee to Pennsylvania. Oh, I didn't see Dog come. Thank you for hitting the thumbs up, Kels. I appreciate you. Wow, with the 38 months going strong. Love you too, girlfriend. Thank you. So he never did come here. Therefore, assuming arguendo that this was an enterprise and some predicate act of RICO magically materialized, how in fact did the so-called claim non-detailed conduct of this non-existent enterprise stop search efforts of the missing teenager when you view the words of the plaintiffs? It did not. There is no RICO injury based on these allegations, and this court should reject these claims for what they are: a ginned up, purposeful attempt to silence free speech over hurt feelings conjured up by the claimed scrivener of these filings, plaintiff Hazafrasu. Now, I like this part, and you guys will too. Here we get into Betty. Calling a public figure a grifter or a tragedy pimp is not defamation. Further, Pennsylvania does not recognize a civil cause of action for criminal harassment. Any intentional infliction of emotional distress is brought on by plaintiff Griffin by her own quote-unquote bullhorn mouth. One red rose with the 31 months. You ladies are really amazing. Thank you so much for being with me for all these years through all these things. It really means a lot to continuously see you guys day after day, year after year. It means a lot. Thank you. So, any intentional infliction of emotional distress is brought on by plaintiff Griffin by her own bullhorn mouth. Ain't that the truth? Ain't that the truth? Oh my goodness. Seashell with the 16 months. And Maisie with the over 2 years. You guys are amazing. Thank you. So it goes on to say, currently the mother and stepfather, and also don't forget the grandparents of the step-grandparents, I suppose, of the missing teenager have restraining orders against plaintiff Griffin in Sumner County, Tennessee. Moreover, plaintiff Griffin has upcoming court dates on her violation of those restraining orders. April 2025, where, upon all information and belief, she is not allowed to speak about these individuals. Amazingly, the screenshot of her latest video reveals it is just fine for Plaintiff Griffin to use the same type of words she claims is defamation when it concerns people she dislikes. See Exhibit 3. Oh, piece of shit. Sebastian Rogers, piece of shit mom speaks. Hiding, not searching. Ain't that interesting? Just like her calling Jay a wasteful piece of shit. I guess that's okay. But to Brittany, that's defamation. But it gets better. It gets a lot better. And I'll show you where. Barbecue's attorney did a fantastic job as well. The cause of action set forth in conclusory fashion, which fails. That said, Plaintiff Griffin cites criminal statutes which are not appropriate in a civil cause of action. Notably, these multiple claims under one count are not Rico predicate acts. In totality, count 2 is improperly before this court. More importantly, the criminal statutes were raised to instill fear into these two women that if they did not succumb to the demands, extortion of the voice of these plaintiffs, driven and controlled by Nick the Hat, would be facing criminal charges. Goes on to say, here it must be shown that 2 or more persons combined or agree with intent to do an unlawful act or otherwise lawful act by unlawful means. I think if anybody here is making a RICO, in this case, there is no such cause of action for coordinated defamation. Accordingly, this claim fails, and amendment would be futile as Plaintiff Griffin cannot make out a claim upon which relief can be granted. Goes on to say, the request elements of a cause of action of interference. This one's also interesting. The purpose or intent to harm plaintiff by preventing a relation from occurring, the absence of privilege or justification. Here, Plaintiff Griffin fails in this count because there is no actual prospective contractual relationship that she lost, nor actual damage she pinpoints. These are nothing more than vague and conclusory allegations. Moreover, there is no privity in any manner between the parties. Thus, this claim fails and it would be futile to allow amendment because Plaintiff Griffin cannot state a claim here too upon which relief can be granted. To be clear, if one's vehicle needs a fuel pump, does one enter the auto parts store and ask for some parts instead of a fuel pump? Who are the some people that distance themselves from Plaintiff Griffin because of these defendants? If this vague allegation is fatally detrimental to Plaintiff Griffin's claims, even if some people did distance themselves from Plaintiff Griffin, she has not set forth, as stated, a prospective contractual relationship that was lost. Finally, perhaps the fact that Plaintiff Griffin is out on a $20,000 bond on a restraining orders out of Sumner County, Tennessee, is the cause for her potentially lost vague income prospective relationships. I mean, that could be true. This count does not set forth a RICO. Here we have one of my favorites. Now we move on to Plaintiff Jackson, which, again, what date are we on? Because discovery was requested. Does anyone recall what date discovery was requested from Miss Jackson? I could probably check by doing this. Let me see. February 6th. Ooh, tick-tock goes the clock. Tick-tock goes the clock. All right. So here we have Plaintiff Jackson fails to assert any statements that rise to the level of defamation. Additionally, this count is improperly pled, citing 2 causes of action under one heading. See the Scrivener, Plaintiff Hasafrasu, for an explanation. Finally, the statements attributable to Ms. Sang about Plaintiff Jackson do not rise to the level of intentional infliction of emotional distress. To prevail on a claim of intentional infliction of emotional distress, the plaintiff must prove that the defendant, by extreme and outrageous conduct, intentionally or recklessly caused the plaintiff severe emotional distress. I think that would be like accusing somebody of having warts and claiming that they send out photos of. But hey, what do I know? What do I know? To prevail in a claim of intentional, oh, that's right, we just read that part. Extreme outrageous conduct is not defined, but it must be something more than annoyances, threats, and insults. The claims must not be about vague feelings of sadness or upset, but require some evidence, such as medical records or testimony demonstrating how the distress impacted one's daily life. A footnote of 6. Jessica looks forward to a shifting and thorough examination of plaintiff Jackson's medical records, substantiating her claims of emotional distress if this matter moves forward, such as medical records or testimony. Furthermore, there must be a clear connection indicating that the distress was caused by the outrageous conduct plaintiff Jackson fails in this regard on all fronts, as will be set forth more specifically below. Let's go ahead below and see. Oh, now we get into Plaintiff Rogers, who fails to assert with particularity what statements were made along with the time, place, and manner of said statements. If Plaintiff Rogers' claims survive this motion, we look forward to delving into his medical records as well. These counts are improperly pled as they seek civil relief under criminal statutes in a civil forum. The endangering the welfare of a child cause of action is almost as laughable as the Rico claims. Even if this was a proper cause of action for a civil forum, it would have to be shown the accused had a duty of care, acted with knowledge or reckless disregard, and created a situation that posed potential harm to the child. Neither myself or Barbecue owes the search for a missing teenager, nor the missing teenager a duty of care. Then they go ahead and quote the actual crime that they're alleging. Endangering welfare of a child does not apply here too, as there is no allegation either myself or Barbecue supervised the welfare of the missing teenager. Additionally, this is a criminal charge, not a civil cause of action. This Commonwealth would need to bring charges against wrongdoer for endangering welfare of a child, not these plaintiffs. Also, unless this missing teenager was at some time supervised by someone in Delco, PA, Tennessee would be the prosecuting forum for such a criminal charge. Clearly, this is another example of the unattenuated drivel of plaintiff Hasafrasu and his cadre of succubants. I don't know that word, but we get it. All right, let me find myself and fix it. Hold on. All right, there we go. The allegations fail to rise to any level of defamation. There is another part down here. Claims of impeding search efforts is not the intimidation of a witness in any manner whatsoever. The other counts are not predicate acts, blah, blah, blah. Civil harassment, not pled correctly. Here comes Plaintiff O'Donnell. I don't even freaking know her. The count seeks relief under a criminal statute. Plaintiff O'Donnell fails to assert who is the witness and fails to name the underlying case the supposed act references. Now we get into Julia. Even if this count was properly pled, it would be Plaintiff Valenti's mother that would have standing to make these allegations. Therefore, this count fails. Consequently, amendment would be futile as Plaintiff Valenti cannot make a claim upon which relief can be granted. Plaintiff Valenti has no authority to stand in the shoes of a prosecutor, Commonwealth, to bring such claims, if they existed, which are strictly denied. Again, amendment would be futile. We obstructed the search. Here comes Hong. In addition, since when does Plaintiff Hong stand in the shoes of or is positioned to owe a duty of care to the missing teenager to be able to make such claims? As for the stalking claim, Plaintiff Hong's allegations are conclusory and vague. Moreover, he fails to attach a police report concerning this claimed incident, which only set forth here too whether it occurred to position defendants in a false light before this court. For all we know, Bigfoot was the perpetrator, as Plaintiff Hong amazingly fails to assert the person on his property was a female. We are not persuaded by these false allegations, which cannot be attributed to these defendants, and neither should this court. There's no cause of action. Oh, I'm blocking it entirely. Sorry. Oh, I like this one. The counts here too again seek relief under criminal statutes, which are not properly before this forum. Plaintiff Hasafras uses these allegations to scare these defendants into thinking they are facing criminal charges in this civil forum. No doubt these claims were brought about for the purpose of silencing opposing points of view. If one goes on social media, expect critics and criticism. When you yourself attack people, expect attacks back. To be clear, it was plaintiff Hasafrasu that cooked up this legal scheme to bring Jessica into this case for jurisdictional convenience. Yet, it was also plaintiff Hasafrasu that doxed Jessica's family on X on or about September 19th. Make no mistake, plaintiff Hasafrasu's meretricious mechanisms, of incredulous beyond the pale claims were exposed by defense counsels here too. Now, I have to thank a subscriber for this. A subscriber pointed this out to me, and I would have never seen it otherwise. Susie, thank you so much. I'm sorry, I'm not on YouTube screen, so I apologize. I'm not responding to you all. I will get there. But check this shit out. For instance, plaintiff Hasafrasu altered the dates of when and what occurred in late September of 2024 to effectuate his scheme. In that regard, the call Jessica made to Attorney Lasniak took place on September 25th, not September 19th as set forth. See Exhibit 4. Would you looky there? There is my phone record showing that I called Joseph Lasniak on September 25th, and he called me back on September 25th. But in their filing, they put the 19th. You know why? Because plaintiff Hasafrasu makes this allegation to deceive this court that Jessica played a role in calling his parole officer. Even if Jessica called plaintiff Hasafrasu's parole officer, there's nothing illegal in reporting a parolee to his parole officer when one claims that he is searching for a missing teenager in Tennessee, when upon all information and belief has state travel restrictions. Now, give me just 1 second while I look for this for you all to make this make more sense. When one puts their business on YouTube and people know you're on parole, expect calls. Footnote 7, despite the assertions of Attorney Lasniak at the hearing on February 18th, see notice of hearing, if there was no validity to the calls to plaintiff Hasafrasu's parole officer, he would not have been placed on strict restrictions. Instead of following a process to counter those restrictions, plaintiff Nick the Hat uses this court to air restriction grievances which are misplaced. And I'll show you all why. I couldn't believe it. The freaking nerve. As you all see, the freaking nerve. So they lied about the date to make it like I was involved and Nick's parole officer being called and Nick being placed under these restrictions when the fact of the matter is I did not even have contact with Nick nor Lasniak at that time. Regardless, plaintiff Hasafrasu's deception and extortion of the voice fails in making a claim here too upon which relief can be granted. You guys remember this? On September 19th, Nick was stated that he should not have any contact with the Proudfoots. Anybody remember this? Well, this happened on the 19th. This restriction happened on the 19th, as you see here, as did this restriction that states he's not allowed to be in contact with any law enforcement. So Nick lied in the filing, stating that I contacted Joseph Lasniak, which led to an influx of calls to his parole officer, when in fact I had nothing to do with it. I wasn't even in contact with them at that point. Hey, nonsense.
Good morning.
Good morning. I'm just showing here how they straight up lied to the courts, claiming that I was involved with them and called Lasniak on the 19th so that he could act like these restrictions from his parole officer has something to do with me.
It's
And I called his parole officer. Not only that, but they lied at court and stated that I posted his probation officer's phone number, encouraged everybody to call.
Yeah, such BS. The dates again, the 19th of September. Imagine that.
Right.
They
and
were
then you have
busy.
here on September 25th is when I first came in contact with Nick and when I first called Joseph Lasniak, and the only time I called Joseph Lasniak, in which he repeatedly said to me that he said, do you feel like, this is his law office, he said, you don't think saying you're coming to my office was intimidation? And I said, no. And I said, I'm sorry if you felt it was. And he said, well, let me make it clear. I didn't feel intimidated. He said it like 3 times. And I said, I'm glad you didn't. That was not my intentions, but I do. So what are we going to do about this? Then he went on to act like, he didn't realize what Nick was doing on X. And then I said, spare me. I can see here that you retweeted PA rules of doxing underneath where Nick doxed me. Whatever. So fucking liars.
They were really busy for a few days
Yeah.
there in September. Real busy.
Then I like this part. Plaintiff Hasafrasu's reputation speaks for itself. No mischaracterization thereto is required. More importantly, these claims are vague and conclusory. As such, there is no claim upon which relief can be granted. This is how they're so stupid. They said it was both open-ended and closed-ended. Can't be both. This is just quoting other laws. This is saying how they don't meet Rico. And then here we go. In the matter at hand, it is plaintiff Hasafrasu that threatened Jessica with litigation over 10 years for not keeping quiet. See my motion to dismiss. Let us be clear. Neither Jessica nor Barbecue have a duty to search for the missing teenager, nor do they have a duty to discuss the case, nor do they have an obligation to discuss the matter in a manner or accord determined by these plaintiffs. That said, even if properly pled and assuming arguendo, a scheme did exist. It was only aimed at a few individuals based on a singular true crime case. Accordingly, the plaintiffs failed to properly plead an open-ended continuity to establish a pattern of racketeering activity. They don't do a valid assertion of facts. There's no the distinguishedness. This is unbelievable. They failed to point out an enterprise. Sarcasm does not equate to an enterprise. They failed to satisfy the minimum person in enterprise. They don't show good cause. La-di-da. Claims about hindering a search failed the RICO requirement to injury to business or property. Plaintiffs failed to step forth the proclaimed actions of defendants were the proximate cause of any injury, whether under RICO or otherwise. Consequently, these allegations are nothing more than a smear and fear campaign to get 2 single mothers who run small YouTube channels to bow to baseless demands designed to silence free speech and inhibit plaintiff Hasafrasu with power over 2 women. The free speech that does not reach the monthly readership of Philadelphia Inquirer's 13.3 million people, despite the assertions of Attorney Lasniak. The complaint asserts that Ms. Sang contacted Attorney Lasniak on September 19th. This is a misrepresentation because Jessica's only contact with Attorney Lasniak took place on September 25th. Again, the reason this date was changed by the Scrivener, plaintiff Hasafrasu, was to make it look like Jessica contacted plaintiff Hasfarasu's parole officer on September 19th as a means to get her ensnared in this nonsense to confer jurisdiction of this court, as stated previously. This was a convenience move for Attorney Lasniak and the man his office is beholden, plaintiff Hasfarasu. These actors believed public pressure would cause Jessica and Barbecue to cave. Attorney Castor, the former general, litigation for 10 years, dogged the bounty hunter, Rico, and a press conference on the steps of the courthouse to announce this action. See Exhibit 5. Oh, that's right. This is where they say they're going to have a press conference. Now he says the representation of plaintiff Rogers going into the prisons for work. See the notes of the hearing. Plaintiff Rogers has not worked as a correctional officer in the prisons at or about the time or shortly after his child went missing. How could these fake conclusory statements impact work when you are not at work?
Yeah,
and then I got one more thing, and I'm going to forward you
Look at
something
you,
nonsense.
Okay.
Nothing screams more than improper purpose than Attorney Castor given the authorization to place his name on initial pleadings with no intent to represent any of the parties. It was admitted by Attorney Lasniak at the February 18th motions hearing that Attorney Castor gave permission, gave his authorization to use his name on the pleadings. With no intent on representing these plaintiffs, the only purpose housed intimidation of these single mothers by a former Attorney General of the Commonwealth, and as these plaintiffs noted, the former counsel to now President Donald Trump. It is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, which is why they are going to be reported to the bar. In this case, Attorney Castor admitted these plaintiffs were not his clients. See Exhibit 6. Oh. Please note that I am not involved in this case, and any indication otherwise is an error. Mr. Lasniak is the plaintiff's counsel. And then see Exhibit 7. As I consider both you friends and colleagues, I would hope that any misunderstanding in that regard is corrected, and the court, counsel, and litigants are aware of my non-involvement. I would rather not do anything official to draw attention to these issues, and I hope, Mr. Lasniak, that you will see to it that no one thinks I am representing Mr. Chapman and your pending action. Defense and counsels did. Okay, so we bet Attorney Castor did not want to draw attention to this issue, but defense and counsels did because it was clear mendacity was afoot. Consequently, the inclusion of Attorney Castor's name was a misrepresentation to improperly extorting Jessica into silencing her right to expression. Then he goes in to show how Nick here, they asked to amend their complaint, but then he put on social media that he has no intent on pursuing Queen Bee. He just wanted to get a reaction out of somebody. Amazingly, plaintiff Hasfarasu put forth on social media that plaintiff at night had no intention of adding Queen Bee. Not only does this show who is controlling this action, but the improper purposes for which they are utilizing this court system. Allowing this case to go forward with this clear abusive process glaring in this court's face would be an utter travesty. Neither should this court nor any other court allow this type of litigation. A 20-year attorney, and he does not know you cannot allege criminal causes of action in a civil forum except actual RICO predicate acts, which are not pled. As a result, this type of behavior needs to be sanctioned to thwart any others, and make no mistake, specifically these plaintiffs, from ever again attempting to use the court system in this manner. Goes on to state all the actual causes of RICO, none of which they list. And then we get back into Brittany. Which again, the clock is ticking for that one. Plaintiff Jackson's assertions. Okay, this is good. Of defamation, or not defamation. Assuming that these alleged statements are defamatory, Plaintiff Jackson does not properly plead defamation, especially for someone that, as a content creator on YouTube, is a public figure. Additionally, Plaintiff Jackson fails to assert with particularity the date at which these statements were made. Clearly, this was purposefully done to avoid a statute of limitations defense, which is 1 year in this Commonwealth. Even if made within the applicable statute period, Plaintiff Jackson would only have a private cause of action against Jessica, not a case brought under this prolixity of drivel, citing criminal violations in a civil forum and alleging Rico violations when they failed to enumerate any Rico predicate acts. In paragraph 136 of the complaint, everybody listen closely here. Put a 1 in the chat if you have heard Brittany say that she's not involved in accusing me of Rico. Drop a 1 if you've heard her say that.
Can I verbally chime in?
Absolutely.
1 1 1 1 1 1 1 1 1 1 1.
That's about how many days she has left to hand over her her answers and requests for discovery from my attorney. Lots of 1s in the chat. So in complaint 36, paragraph 36 of the complaint, Plaintiff Jackson asserts harassment, threats, and defamation fit into a pattern of conduct of a corrupt organization. Do you hear that? You accuse me of Rico.
Not Rico.
That's what it says, corrupt organization.
It has nothing to do with Rico, you silly goose, you.
Silly Willie. None of these claims, even if true, are predicate acts of Rico Enterprise. Notably, in paragraph 137 of the complaint, Jessica was responding to Plaintiff Jackson spewing personal information she had received from a former moderator on her Granny's Watching YouTube channel. With this information, Plaintiff Jackson then went on her YouTube channel and discussed Ms. Tsang's private health information. Regardless, these claims are not defamation, nor are they evidence of Rico. Plaintiff Jackson was just a useful pawn in this game being played out by Plaintiff At Night and Plaintiff Hasafrastu, the ringleader and no doubt scrivener of these filings. After a thorough review, this court has no choice but to dismiss this action because it's nothing more than a poorly pled, evidence-lacking attempt to persuade this court based on her feelings to improperly silence free speech. Then this part's funny too. Mr. Rogers fails to set forth which defendant made the supposed defamatory comment about him. Instead, Rogers makes citations that are vague and conclusory. The claim statement lacks any particularity. With supposedly 2,200 hours of live streams at his counsel's disposal, one would think the statements could be pinpointed before verifying such conduct occurred. They cannot. This now public figure, Plaintiff Rogers, who runs and or maintains his own YouTube channel, goes on various YouTube channels, other social media platforms, and mainstream platforms, makes claims with no basis. This is nothing more than an individual seeking a silent speech that is critical of his own words on the aforementioned platforms. To quell speech he does not like, Plaintiff Rogers has posited inflammatory accusations he cannot support. Even if true, defamation is not a RICO predicate act. At most, Plaintiff Rogers would only have a private cause of action against me, if at all. As step 4, Plaintiff Rogers cannot sustain an action against myself or Barbecue as he fails to satisfy the material elements needed to make out a cause of action for defamation. Persistent sarcasm, which is what they said, is not defamation, nor can it be a predicate act of RICO. Ridicule is also not a predicate act of RICO, nor is telling a public figure or private figure to go see a therapist. Finally, caustic insults without factual assertions amount to opinion, and as such are not defamatory. Then we get into the fact that he accused me of defamation by stating that he was labeled borderline abusive, but he went on to the Law Lodge and admitted, again, that the courts labeled him borderline abusive to his son. If one goes on YouTube and admits such things were said by a court, individuals will not only comment, but criticize you. Without a doubt, these allegations are only set forth before this court to improperly silence critiques which are protected under First Amendment. In conclusion, this is a hypocrisy engine run in full bore These plaintiffs are high on an adrenaline rush of pack mentality, fueled by social media. We are right, you are wrong, using this court to swing the biggest club. Rational thought is set aside by a swarm of de-individuation under a baseless legal witch hunt, which this court must halt under the Uniform Public Expression Protection Act.
Oh, Rico.
Rico. And then this was actually fantastic. You know what's quite ironic?
I'm floating over here on the screen. It's awesome.
Yeah, sorry. I have us all over the place.
No,
You guys
it's
got to
okay.
see this one. This one is fucking hysterical. So, you know how they claim that Barbecue and myself called him a P word, the pedo word?
Oh, but they couldn't date and timestamp where it was said and who said it.
Mm-hmm.
Uh-huh.
So check this out. This was fantastic. Great job to Garen, who is the one who spent 10 years in front of litigation in an attempt. I will never, don't advertise them people in my chat, please. The only allegation concerning pedophilia in the entire complaint appears in the middle of a paragraph of 210. The paragraph is inserted in count, whatever that is, alleging not defamation, but intentional infliction of emotional distress on behalf of plaintiff Seth Rogers. It says that defendants Barbecue and Granny's Watching engaged in a pattern of extreme and outrageous conduct directed at plaintiff Rogers. This conduct includes spreading false allegations of criminal behavior, such as accusations of pedophilia and involvement in the murder of a child, along with threats to his safety. The defendant's actions were maliciously intended to harm Rogers emotionally, damage his reputation, and derail the search for his missing son. Complaint paragraph 210, notably, the complaint does not allege that the accusations of criminal behavior, including pedophilia, originated from the defendants, but accuses them of spreading the information. The complaint is silent on how exactly defendants spread these accusations. It provides no information concerning which of the defendants made the allegedly defamatory statements, to whom the statements were made, where they were made, when they were made. It offers no information on who may have heard the statements. It further fails to identify the statement with any degree of particularity to permit the defendants and this court to evaluate the allegation in context. Other than the existing controversy over the missing child that plaintiffs readily admit to themselves publicizing, the complaint offers no context for these accusations. Plaintiffs detailed their efforts to create a media frenzy around the missing child in the first 46 paragraphs of their complaint. Critically, plaintiff Rogers, who paints himself as the victim of accusations of pedophilia and child murder, has, according to the complaint, worked with plaintiff Dog the Bounty Hunter to publicly accuse this child's stepfather of being involved in the child's disappearance.
That.
If you guys want to see something very fucking ironic, we need to get the thumbs up a little bit higher. Wait till you see what comes up next. You guys will be floored. All right. Plaintiff must not only give the defendant notice of what the plaintiff's claim is, the grounds upon which relief can be met, Pennsylvania rules of civil procedure, the defamation, whether it can be done. Now, applying these well-established rules of pleading defamation claims to the plaintiff's complaint, it is apparent that the complaint violates PA Rule 1019 in nearly every conceivable way. Rather than stating the facts in a concise and summary form, the complaint attempts to compel the defendants and this court to parse through 350 paragraphs of deliberately verbose, rambling, difficult to follow, and impossible to decipher allegations to guess at the basis for plaintiff's claims. Instead of alleging the material facts, plaintiffs throw everything at the wall to see what sticks. This is particularly true for the single allegation of pedophilia that appears in the complaint. Paragraph 210 broadly accuses both named defendants of spreading the alleged defamatory statement without identifying the actual statement. Now we're going to go down here. Here, the plaintiff's complaint only fails to identify Check this out. Plaintiff's complaint does not merely admit that the underlying dispute over the missing child is public controversy, it boasts about the plaintiff's role in creating that public controversy. The complaint devotes many of the first 45 paragraphs to emphasizing the very public nature of the dispute. These include publicizing the dispute through the plaintiff Dwayne Chapman's many live television appearances, publicly increasing the reward for information, and effectively amplifying attention to the case tenfold in a short period. They also admit that plaintiff Rogers and Chapman used the publicity, in significant part, to accuse the missing child's stepfather of being involved in the disappearance. Essentially, the equivalent of accusing the stepfather of allegations of criminal behavior and involvement in the murder of a child, plaintiff's admission that this matter concerns a public controversy of their own creation is significant because it effectively renders the plaintiffs as public figures, at the very least, limited purpose public figures. Which means that they have a, more of a burden to meet. But look at this. As alleged, the accusation of pedophilia is nothing more than an insult. This lawsuit is not about damage to plaintiff's reputation. It is fundamentally about silencing protected expression on a matter of public controversy, not because it's defamatory, but because plaintiffs disagree with it. Now, when you get down here, they point out the court addressed allegations of defamation from a post about a plaintiff in a photograph looking like a pervert or like someone accused of child molestation, blah, blah, blah. In recent years, particularly since 2016, pedophile has devolved into a near ubiquitous insult on social media platforms. At this point, the terms, particularly when deployed without corroborating facts, do not carry the same sting they did 10 years ago. As proof, where are we at on the thumbs up before we get this far? I don't think that's why, Lisa. I don't think they had any intent, such as Nick said. Nick straight up said, we have no intent on adding you to the suit. We just want to see if we got a reaction out of somebody. Wait till you see this. You're going to be excited. This is quite fucking interesting. Good job on this one, Barbecue. Let's slap the thumbs up. Let's get at least to 800. We can do it with damn near 1,400 people in here. And while I wait for you guys to do that, I'm going to use the restroom because we're about to see some really interesting shit. Do you mind, Nonsense? Do you want me to play this little video that's very interesting while I run?
Yeah, you can do whatever you would like to.
Okay.
I'm here. I'm mostly awake. I'm kind of like one eye.
I know,
open.
It's so early for you.
It's okay.
Let's check this out while we get the thumbs up to 800, and I will be right back. You are going to want to see this. It is very interesting, quite ironic, and I say it is a chef's kiss.
Can I say something before you push play?
Really of course.
If you haven't, please go hit the thumbs up. But if you are feeling and have a little extra, please hit up Jessica's Legal Fund, because you can see her attorney has been working their asses off. Their attorneys have been working their asses off, but she's got a legal fund. Please go hit it up. I'm sure the mods will drop it and support, because this, to have her name cleared, has not been cheap.
Oh, thank you so much. I really appreciate your Nonsense. Thank you.
I got to do my hype girl thing, because supposedly I'm doing it behind the scenes, so I might as well do it in front of the scenes too.
Oh yeah. Asking if I'm like mentally okay is such a, hype thing. Wow.
I know. Okay, go run to the bathroom.
All right. Thank you.
Corporate America. Have you had it up to here with people speaking out against your corporation? Protesters, activists, journalists, any entitled citizen at all can criticize your corporation. The solution? SLAPP lawsuits, which is really just a fancy way of saying, shut them up in court. The time they spend scrounging documents, legal fees, and court filings is time they're not protesting at your corporate headquarters. Turn whiny local citizens into beleaguered courtroom defendants with just one lawsuit. But don't take our word for it. Just listen to these satisfied CEOs. Bunch of old-timers complained when I was selling their town's water rights, so I sued them silly. Thank you, SLAPP lawsuit.
Some pesky lady and her friends had the nerve to speak out against trash and coal dust we were dumping in their town. So we scared them with lawsuits, and we're still dumping to this day. Thank you, SLAPP.
You can bully anyone in court, even an imaginary Twitter cow that says mean things about an awesome and gifted politician. Thanks, SLAPP.
We even used a SLAPP lawsuit against a guy who made a snarky comment online about our multi-billion-dollar company. And it felt great. Yes, these lawsuits and more can be used to shut up free speech that is dangerous to your corporation. Don't think you've got a case? Don't worry. Winning your case doesn't matter. Tying up those loudmouth citizens in court is what matters, and that's a win.
Okay. So I found that important for several reasons. And one being, listen, if you don't advertise people in here, please, I don't watch these people. I don't give a fuck what they're saying. Because it isn't about winning. It isn't. When people say like, oh, well, Granny keeps talking, she should have shut up. If that was the case, then I would have just went ahead and did what they wanted me to do. Why would I shut up when that is their whole purpose is to shut me up? Why would I? Oh, thank you so much. I missed a lot of stuff over here. Thank you, Barbara. So this is where it gets really, really, really ironic. And I know we could get the thumbs up a little bit higher, but that's all right. I trust we will get there. So, as proof, this court need look no further than recent social media posts by some of the plaintiffs in this case. Earlier this year, plaintiff Hong posted the following on his social media account. You ready for this?
Oh,
These people have no respect for little Sebastian's life. Bastards. Traffickers, drug dealers, drug addicts, abusers, wife beaters, enablers, sex offenders, pedo Carl. Look at that. Pedo Penny, pedo Proudfoot, monsters.
Well, I'll be not a plaintiff saying all of those things.
Oh, but it gets better.
Uh-oh.
Plaintiff Chapman on his social media has referred to someone as a child pedophile. Last year, plaintiff Nick Hasafrasu repeatedly used the term pedo, including to accuse a Nickelodeon producer of being a perverted pedo. He went on to call for the arrest of executives at the company, stating, pedo galore at Nickelodeon Disney. Another one of plaintiffs, Andrea Griffin, aka Bullhorn Betty, used the term pedo in reference to the parents of another missing child. The point of this is not to condone the use of the term, but to recognize that the terms have been defined into mere insults or vituperative outbursts, which are undoubtedly offensive, but not actionable in defamation. Although it served as a central feature of plaintiff's presentation at oral argument, the alleged pedophile accusations appears in the middle of just one of the 350 paragraphs in the complaint. It was included as a throwaway allegation in Plaintiff Rogers' fatally flawed emotional distress claim. As such, it is woefully deficient on the pleading standards required for defamation plaintiffs, especially those who are public figures, such as the plaintiffs in this case. As alleged, the statement is nothing more than a type of caustic insult that many of the plaintiffs themselves use on their social media accounts. Here's Exhibit A. This is Hong himself calling somebody the P word.
Whoops.
Here's Exhibit B. Dog saying, haha, not a grown natural pervert, but a child P word. Oopsie doopsie. Oh no. Here we go to Nick. Great work getting this pedo off the streets. We need to execute these creeps. And Dan Schneider is a perverted pedo. And then he goes on to say, seen rather than pedo island. You'll find a chunk of that a list along the way. And then here we have Bullhorn Betty accusing Don Wells of being one.
No, not another whoopsie oopsie.
Oh, yeah. And
Oh,
then we
no.
have Nick. Pity is nothing but a farce of a distraction of us Nickelodeon executives. Pedo galore. I love to know how many news network executives visit Pedo Island. Uh-oh. And not only that, but yeah, how's that for interesting?
Well, also there's one more exhibit that could be added to that. Tony Mathis, one of the other plaintiffs, saying it publicly and asking about another creator, Dolly's brother, and saying,
Oh, that's right.
Yeah, there's a clip of that from TikTok too. Huh.
Very interesting. So here we have Bullhorn Betty calling another parent of a missing child an actual pedo with her lovely face even attached to it. All right, we ready for the main event?
Uh-oh. We need some like
Intense music.
intense music leading into this.
I know. Oh wait, I thought I had us even. How come it's not? Okay. So now we have the transcripts from the hearing on the 18th. If you have it, please hit that thumbs up. Good morning, Danny. I feel like we are very I'm very confident and where we are. Like I'm very confident that somebody did give a donation to the Give Send Go. Thank you so much. Thank you.
Yay.
I see an email from it. Okay. Are you guys awake in the chat? Let's put some band emojis in the chat. We got some band emojis. Is the band awake?
Drum roll, please.
Drum roll.
I can't do it. I can't make sound effects. I can make horrific
just
squeaky noises. Cue the marching band. Trumpets up.
That's right, Sarah Lee. I'm fully aware of what some know-it-alls think. I want to point out to you all that a lot of those people were within my chat when Seth Rogers himself went to social media and spilled his own son Sebastian's trauma. A lot of the people that are now criticizing me for my commentary not only were on my panel as I made that commentary, but were in my chat agreeing. Okay? So the irony that they now don't like me, which I believe is solely based on who I like that they don't, that they now feel like they have some type of moral standing. You sure didn't take that moral standing as you were in my chat calling Seth Rogers a fat ass. But you hit all your content, didn't you? So you don't think it's there. Let me, like that video said earlier, you too can go through this based off a tweet. You too can face something like this. The fact that any of you quote unquote curators over there would sit there and support this simply because you dislike me is fucking pathetic. Because I swear, and I know without it, that if it were you being accused of interfering in search efforts, being accused of fucking Rico, and being accused by psychopaths in your own backyard, you too wouldn't just shut up about it. You too would fight it. So I find it quite ironic that any of you have the nerve to sit over there and act like you're on some type of high horse and you're better than when you sure as fuck could land yourself in the same situation. By the way, how much respect do you pay to Wade Wilson's victims as you sit over there and glorify his phone calls? But I digress. You're better than me. Okay.
Oof.
Okay.
Facts upon facts upon facts.
Not a moment of silence, nothing. Matter of fact, for one of them to go live on the day that Sebastian disappeared and intermingle drama into his disappearance was not only despicable, but so telling to how much better you think you are, but how people see you to be. on the anniversary date. But yeah, that's the only way these people get seen. That's the only time you see these people. They're not over there spreading awareness. They're running their fucking mouths, but they're better. They're better than everybody else. Uh-huh. Okay. All right. So we now present to you all. Oh, I know. They're not worth a moment of time. It's just the irony of it all. It's the sheer fucking hypocrisy of it all.
Oh, there's so much hypocrisy. There's so much with that. But like I said,
And here's my
you gotta
biggest
respect
thing,
them.
right? You can go ahead and say, Granny said this, Granny said that, but where the fuck is the proof of it? I don't give a shit what you twisted what I said to be in your head. I don't care about that. If you are the type of person that you would roll over and allow somebody to accuse you of something as egregious as Rico, and you are somebody that would roll over and just shut up because somebody tells you to shut up, well, then shame on you. You don't stand for what you claim to stand for. At the end of the day, you can sit there and say, oh, well, what about Sebastian? Again, ask those that are responsible for Sebastian, what about Sebastian? I don't have an obligation. At this point, this is my real life. You all sit over there and act like you would do this and you would do that. No, bullshit. Bullshit. It all comes down to fucking money for you people. It's so obvious in everything you say.
And even if they would handle it differently, good for them. That's not how you're handling it. And you have legal representation who is helping you handle this
Right.
properly. And you are being accused of Rico. That is, it's not just a simple injunction. It is a lawsuit that is claiming Rico. It's pretty easy to see what's going on here.
Not only that, but do they even know what the injunction says? The injunction says for us to delete our social media, to shut up and never speak again, to direct our audience to never speak again. It's literally unconstitutional. And you think I should agree to that? Because some fucking nobodies came along and decided they were going to strong arm me via the legal system?
Yeah, we're not going to normalize behavior like this, weaponizing the court system with false allegations because of hurt feelings. This isn't a defamation case. Again, I'll say it for those in the back. This isn't a defamation case. So their arguments are irrelevant, period, point blank, end of story. And again, I know it probably goes for you too, but I have to respect somebody to give a shit about their opinion. And when you don't have any respect for people, you just kind of ignore and move on.
Right. Not only that, but there's 5 attorneys, 5 practicing attorneys that literally say that this suit has nothing to do with defamation. That's just thrown in there to add weight to their baseless claims.
100%. I'd love to have them argue a few of those points with your attorney. Oh, it's not Rico. It's just all they had to do was be quiet.
Yeah. Mm-hmm.
Huh. That's pretty simple compared to what's really going on here.
If all I had to do was be quiet, they would have sent me a cease and desist. I never received a cease and desist, ever. You don't get to go to my local courthouse, put in a caption of my neighborhood that I'm participating in a Rico, and think that I'm going to roll over and just shut up. Some of them can't even refrain from responding if somebody nearly mentions their fucking name, but they would shut up if they were accused of Rico in their fucking backyard? Okay.
Well, rules for thee, not for me.
So February 18th. On February 18th, the courts began. They now declare this courtroom in session. The court, good afternoon. Everybody have a seat. They then go out and they say, this is At Night Media, LLC versus Barbecue Lady and Granny's Watching. They give the action number. Mr. Lasniak, I see you're here. Mr. Lasniak responds. Do you want to do Lasniak or you want me?
Oh, yes, I can, but I can't see it.
Oh, hold on.
You're okay. I can't read nothing. It's just a screen.
LLC, yeah, they're a limited liability company. Although they're not a private agency.
Oh, okay.
I emailed it to you. I don't feel comfortable really having it on the screen.
I got it. I got
Yeah.
it. Okay. So we're starting page 3.
Yeah. Might as well skip all the like introduction of who's there, right?
Yeah. It says, I'm playing the behalf of Mr. Lesniak. Yes, good morning. Afternoon, Your Honor. Joseph Lesniak for the plaintiffs.
Let's
Attorney
jump
number-
down to number 5 where the judge actually begins.
Okay.
Where it
Page
says
5?
the court, that's the extent of it. So it's not an issue for me. It can't.
Got it.
All right, to paragraph to number 10.
Got
So
it.
the judge says here, all right, very good. You can all sit down. We're here today because, as set forth in my notice of oral argument from February 12th, there were 2 motions that were filed pursuant to 42 PA, and that's, I believe, that's the so-called anti-SLAPP statute. And under that statute, oral arguments has to happen within 60 days after those motions were filed. The first of the 2 motions were filed. The first of the 2 motions was filed on December 20th. So I believe today is the day we have to have the oral argument. So here we are today for purposes of that oral argument. My understanding from my review of the 2 motions, and there's a bunch of things in the case that have been filed, none of that is before me today. But my understanding is that there was a complaint in October, filed in October, alleging various causes of action, including defamation, intentional infliction of emotional distress, cyber stalking, cyber harassment, civil conspiracy, and Rico claims against the 2 defendants. The 2 defendants, again, as I understand it from the motions that we're hearing or our argument on today, that those 2 defendants are Miss Granny's Watching and Miss Barbecue. Barbecue woman, barbecue, or barbecue lady. Which one is it? The court clarifies Barbecue's last name. The court, Barbecue. So Miss Granny's Watching and Miss Barbecue host true crime podcasts that are broadcast on the internet. And on those podcasts, like any podcast, I suppose, or at least the ones I'm familiar with, they take calls, they make comments, they express opinions about crimes and investigations and incidents. And the motion asserts that the topics about which they comment on their podcasts are from public sources. And as a result, the motion asserts that the lawsuits have to be dismissed because what they engage in, they, the defendants, is publicly protected free speech. And that the purpose of the lawsuit is to chill that free speech. Is that pretty accurate?
Yes, Your Honor.
All right. So I'll hear argument. I guess we'll start with the movements. I'll hear argument. As you know.
Your Honor, if we can, before you hear argument.
Yeah.
The plaintiffs are asking for a continuance per the law that allows for limited discovery.
Uh-huh.
We're asking that, Your Honor, because when we filed the complaint, the exhibits were digital, as you can imagine, Judge, because there are YouTube channels.
Uh-huh.
Office of Social Support would not accept digital exhibits, and so we are waiting for service to provide the digital exhibits. According to court administration, about 2 months ago, service hadn't been effectuated on one of the 2 defendants yet.
Had or had not?
Had not. Even though we served them with the sheriff's department, I got that because I contacted court administration to try and get this listed for the motion to amend the complaint. I know that's not before Your Honor today, but Your Honor has the right to entertain a continuance request so that we can provide the digital evidence. We can have Mr. Martucci on the record accept service on behalf of his client because it has not been accepted according to the civil court administrator, Ms. Bumpgard, because somehow the sheriff's service could not effectuate correctly either the motion for preliminary injunction or the complaint. I'm not sure, Judge. I did reach out to both counsel. Mr. King did not provide an affidavit.
Did
and signed-
provide.
Did provide. I can't read like that. I can't plug my nose and read like that.
Yeah, it's okay. Go
You
ahead.
sound
We
like-
did, that was good though.
I
That's
couldn't.
gonna hurt.
Well, I can't even breathe. I'm like, whoa. Mr. King did provide an affidavit and signed it stating that his client has been served. Mr. Martucci instead submitted an email saying, this is ridiculous. It's been served. And that's it. That was not enough for Miss Bumgardner. We need something that shows Miss Granny's watching has been served.
Is there an issue on service? Now here's my attorney. Judge, there's no issue. The sheriff served my client on November 18th. It's docketed. The sheriff's return of service was docketed right after. Okay. There is no rule that I have to provide an affidavit of service to plaintiff's counsel when I'm representing a defendant. In fact, there was prior counsel for Miss GW at the time with regards to this. So there's no issue with respect to service? So there's absolutely no issue. There's never been an issue. It's been served. This is fabricated nonsense.
It is not, Your Honor.
All right. Well, so the sheriff served. The defendants they're not contesting service.
Now they're not, Judge.
So they've been served.
But I didn't know that until today.
All right. And then here's my attorney. Excuse me, I sent you a letter. I sent you an email that stated we don't have to sign a proof of service. The sheriff served her. That's sufficient. The sheriff handed it to her. He filed a return with this court. That's service. You look at the docket. That's service. And at no time in any communication from me or prior counsel did you get an email saying we weren't served. Okay, well, in fact, your client was. Hold on, they're saying that internet notice was served. They've been served. They've been served, dudes. You don't need to shout at each other. Their service is not an issue, okay? Service is not an issue. So what I want to hear, I did see in this statute that obviously I have to have an oral argument unless I extend that time period to allow for discovery for good cause. Correct, Your Honor. Okay. Or for good cause. So what kind of discovery do you need, Mr. Lasniak?
I have the discovery to hand to defense counsel. I believe it would be relevant to them to have the exhibits in the discovery in this case and to continue the continuing course of action. So we're asking the court for a short time to provide that discovery. It is hundreds of hours of digital evidence, Judge, that I have on thumb drives that Office of Social Support would not provide.
It's supposed
And
to be judicial support.
Oh, sorry. Thank you. I'm with
No,
you.
so it does say social, but it should be judicial. Why so fast? All right, we'll slow it down. Sorry.
Are we going too fast?
Yeah. I felt
Even
like
the
we were.
21st century would. Oh, let me read that again. It is hundreds of hours of digital evidence, Judge, that I have on thumb drives that the Office of Social Support would not provide, and even the 21st century would not accept. I could not put it into a document form because it does not exist in a document form. It is in fact digital evidence of YouTube, as Your Honor stated, but this has to do with podcasts that in which this information and the information came out. So we're asking the court a chance. We're asking the court a chance to do that as well as any other discovery that may be needed in this case for this oral argument. I understand, Your Honor. This is, the last minute. But again, we didn't know until Mr. Martucci stated that service had been rendered. And that, that we're trying to get this listed for the motion to amend the complaint, Judge, because we're asking for, and I understand the motion to amend is not before Your Honor, but the amended complaint needs to be decided before a SLAPP motion can be filed because the complaint is.
Why do you need leave? I saw there was a motion for leave. Why do you need leave?
Just because, Your Honor, we're asking to change the complaint and by the complaint information.
You don't need leave. Has there been an answer?
There was an answer to it. Yes, we did not file. We were waiting for service. And you would believe that.
So really quick to inform you all, they did not need to request permission from the courts to amend. They simply could have amended. That's big to remember here. They never needed permission from the court. They could have just amended. So she goes on to say, there's been an answer to the original complaint. Which of you filed an answer to the complaint? So an attorney says, no one has. That means there are preliminary objections, Your Honor.
Right?
Okay. And okay. So if there are preliminary objections,
That I had 20 days to file. I understand that, Judge, but I did not do that because service hadn't been effectuated according to the court administration.
Mr. Lasniak, you don't need, there's no answer. There's preliminary objections. Miss Barbecue, I guess, filed a complaint. Here's my attorney. And I joined those, Your Honor. Okay, so now here comes Mr. King. Your Honor, now the judge, you file POs and then you can just file an amended complaint.
And we were waiting for service to be rendered, Judge, or a decision being made.
So this is the judge basically saying you didn't have to wait for us. What are you talking about? Okay, so here comes Mr. King, and this man's very tall, very well. I'm going to enter my Mr. King. Judge, the plaintiff could have filed an amended complaint at any time with respect to Miss Barbecue because there is the first issue that we ought to get out is who are the lawyers in this case? Because this gentleman added Mr. Castor, who I've known for many years, as counsel on this complaint. And that's part of what's going on here. The intimidation that's being thrown at these two women. And I would commend the court to, or recommend to the court to take a look. There's a wonderful brief filed by Ballard Spar in a case called Salam, SALAAM, first Donald J. Trump. This is in the East, in the federal court in the Eastern District. It's case 224-CV05560-WB. It was filed on January 16th of 2025. This is an amicus brief filed by Ballard Spard that outlines the validity of this particular SLAPP statute that we're here on today. This stuff about discovery and amending a complaint, the amended complaint that's offered is simply to add more people into this already ridiculous action that's been brought. This action, if the court has had the opportunity to read this complaint, this 300 and some paragraph dialogue that's before the court cannot stand on any aspect of a complaint that's required to be filed under the rules of civil procedure. Every aspect of this complaint is improper. There isn't a single properly pled allegation. There are people identified as plaintiffs in this complaint, Your Honor, with no allegation about any claims whatsoever. This fellow, Dog the Bounty Hunter from TV fame, is added to try to intimidate these two poor women that had to put up with this stuff. But if the court would take the time to read the brief filed by Ballard Spar, it is a terrific brief. It says what the purpose of the statute is. And what the purpose of the statute is to stop this kind of nonsense. And discovery is more nonsense added to an already egregious scenario that's before this court. And, well, except that legislation, the statute, actually allow discovery when a motion such as yours is made. If in your discretion you see that's something reasonable, what of 350, what's the discovery? Which is why I asked Mr. Lasniak, what's the discovery that you need?
Some information, Judge, as to the basis of their podcast. So we have podcasts, Judge, going all the way back to the beginning of October from these two defendants regarding my clients and statements made about my clients. Things like calling them a pedophile, calling my client's probation officer, and making complaints, and all sorts of other outlandish accusations and defamatory accusations.
That's not discovery, Your Honor. Now, my attorney, that's not discovery. You just said.
It is, because
you just said that you have hundreds of hours of exhibits and you need discovery? That's not discovery. And the claims you make under Rico, defamation is not a predicate act for Rico. Harassment is not a predicate act for Rico. None of them. There's 35 predicate acts for Rico. You don't know any of them. You haven't properly pled any of them.
Your Honor, may I?
There's no need for discovery when you have all this information already in your possession. What? It says inaudible. She said,
it says inaudible, so that's all.
Oh, I'm going to show it. I'm going to show it. Right here, Mr. Lasniak, inaudible.
That's all I got.
Okay. No, that was good. Oh, all right. What's in the, hold on. What's in these digital exhibits that OJ asked that you say couldn't be filed?
The podcast, Judge, the information that it is says in the complaint that verifies the information that is pled in the complaint, and it is provided, and it is continuous and ongoing, Judge. And there are podcasts from just this past weekend regarding this hearing and everything else and everything involved, Judge. This is a continuing course of conduct as though and identify several.
Judge, in his argument, he in the Rico complaint, he argues that it's a closed-ended and an open-ended. Okay, it cannot be both. You put the exhibits. Part of this thing was you delivered these to a podcaster. This whole thing before my client was served on October 18th so they could talk about it. And all they did was mention Bruce Castor. Bruce, oh, this is serious. This is a federal crime. This is federal crimes. It's not a crime. This is not federal court. This is a civil court. On top of that, you put all those exhibits and all those things you had since October 18th to file those things, Mr. King, Judge, and you didn't. Judge, if I may, you waited. You put them on a website so the public could go out and castigate these two women. So you go out and go, oh, look at these things. Look at these affidavits and nonsense. Your Honor, may I? And that's what you did. And now you want a continuance? Hold on, Mr. Mertucci. I'll hear from Mr. Mergarian. Mr. Mergarian. Do you want to do Mr. Mergarian? You got a manly voice? Okay.
Oh, well, I can dig deep.
You guys guess when is my attorney by putting a 1 in the chat.
Who is Mr. Mergarian, by the way?
He's the one that stood in front of legislation for 10 years to pass the anti-SLAPP.
That's what I thought. I was just getting confused on names. Oh, shit. What page are we on again? I just bumped it.
Oh, shit. Let me see. We are on page 17.
Okay, thank you.
He's very very tall and like, thank you, Your Honor. He's like that, like very chill.
Mild-mannered.
Yeah.
Okay. Thank you, Your Honor. Just 2 points. The discovery is allowed to delay this particular hearing that we're here on today. Okay? The motion for discovery should have been made well before the expiration of 60 days, which is today. But instead, we come here prepared to argue on the motion, on the anti-SLAPP motion. And then he ambushes us with this request for discovery at the last possible minute while we're here to argue the motion for hearing. Second of all, to the extent that he has exhibits that are electronic, nothing in this world could have prevented him from actually transcribing those exhibits or the portions that he deemed to be defamatory and included those allegations in an amended complaint or in his original complaint. So the request for discovery is nonsense, and it is also ridiculously late under the statute itself, where the whole purpose of the statute is to stop folks like these two women from being victimized by SLAPP lawsuits that just drag on and on and on. And you,
Mr. Lasniak, when I asked him what discovery he needs, he said he needs discovery as to the basis of the defendant's podcast. Mr. Lasniak, I'm not sure that discovery as to the basis of the defendant's podcast is the type of discovery that is envisioned by the statute that the defendants have invoked to file their motions. The discovery that's allowed is limited discovery if a party, and that's you wanting the discovery, shows that specific information is necessary to establish whether a party, now that would be the defendants, have satisfied or failed to satisfy a burden under section 8340.15 relating to the grant of immunity. You tell me, but it doesn't sound like, I need discovery as to the basis of their podcast is any kind of limited discovery that shows specific information about a burden that they are immune from your lawsuits.
Mr. Lesniak, again, that's who I am. Yes, Your Honor. I believe that there were interrogatories that can be filed to ask questions about what they mean on these hours and hours and hours, hundreds of hours of podcasts. I believe that, we're limited. I'm not talking about expanding it out, but what is...
Judge, I've already started discovery. Hold on, Mr. Mertucci. Mr. Martucci, I know you're very animated, but this is a one person talk at a time thing. You got it. Sorry, Your Honor. And right now, I want to hear from Mr. Lasniak. So,
I believe there's information that can be garnered on a limited basis, Judge, to find out what it is that these defendants had intention as far as these podcasts. These podcasts have inflammatory speech. They have defamatory speech that has defamed my clients and has led to their reputation being defamed. And I believe that there's information out there, interrogatories that can be filed on a limited basis with these defendants to answer regarding their statements on hundreds of hours of podcasts.
I want you all to think about this for a minute. You're already claiming to know what we meant when you accused us of defamation. So why on God's green earth would this guy now need discovery to ask us what we meant? I don't care that it's inflammatory speech. I could say fuck this, fuck that, and fuck you. That doesn't matter. But to say interrogatories, whatever it's called, that to be filed on a limited basis to answer regarding their statements on these hundreds of hours, you already put what you think we meant on them. Like, you get what I'm saying? Like, it didn't even make sense for him to even request that.
All this is rambling. Like,
right.
Everything is like, I'm,
Right. Like, how do we get out of this?
Yeah.
All right. So Mr. King says these statements.
And I believe, I'm Lesniak again, just so everybody knows. And I believe that there is relevant for this limited basis in an anti-SLAPP, Your Honor. This is relatively new statute, as Your Honor is aware, in the Commonwealth of Pennsylvania, passed literally in July of 2024. It then had required the Supreme Court to what is that? What?
Now you're making. Now I'm looking at it, you're making me mess it up. Promulgate.
Like, okay, rules of civil procedure that have not been promulgated yet.
Promulgate.
We're asking for some leave and some leeway to allow us that opportunity. Did we wait for the last minute? I don't believe so, Judge. Even though I know we got notice of this from Mr. King, we got nothing from Mr. Martucci because, as I had the email from Miss Bilbro, service wasn't effectuated.
So I want to point out he now changed the name of the court clerk and he's back to discovery. He's back to saying about discovery, like, although I got it from Mr. King, I got notice from Mr. King, we got nothing from Mr. Martucci. Mr. Martucci didn't owe you nothing. Here's two things he said wrong. He said that he had the sheriff serve us. No. Barbecue's attorney accepted service on her behalf. Therefore, he would let Mr. Lasniak know we received service. In my case, I was served by the sheriff. Therefore, we don't have to put in that we received service because the sheriff did it. The sheriff made sure that it was docketed that I received service. Not only that, but I also came back to social media and told all of you that I was served. And Nick tried saying that it should be considered me being served by the fact that I acknowledged it on YouTube. So this whole argument that he was unaware we were served, then why didn't you attempt service since then? You know what I mean? Like, if you really thought since October that I haven't been served, why haven't you even attempted service?
And why is it switching court clerks now?
Right. Exactly. Yeah, exactly. So here comes the judge. Hold on. But we're not revisiting the service issue as a non-issue. So if I'm looking at one of the motions, right? And the motion is brought pursuant to the anti-SLAPP statute. And the upshot, as I said in the beginning, is that the lawsuit itself has to be dismissed because what it alleges is publicly protected free speech, right? And I'm looking at paragraph 10 of whose motion? Granny's Watching's motion. So that's your motion, Mr. Martucci. The anti-SLAPP statute allows the defendant to file a pretrial motion to dismiss if a party asserts a claim arising from an instance of public expression. A person is immune from civil liberty for a cause of action that is based on protected public expression. That's your client, right? She's immune. That's what you say if any of the following apply, which would be the party asserting a cause of action based on public expression, fails to establish a prima prima facie case as to each essential element of the cause of action. Or if the party asserting the cause of action fails to state a cause of action upon which relief could be granted, and there's no genuine issue as to any material facts. The person against whom the cause of action is being asserted. So who would be asking for discovery here? Wouldn't it be you? And now he looks at us. And my attorney says, Judge, that's one of the issues. Oh, wait. Judge, that's one of the issues here. Let me explain this to you. I'm not sure what the defendant, they don't need anything. First of all, the podcast, they already have hundreds of hours. This is part of what they've done here, Your Honor. They said that my client is going to spend the next 10 years doing podcasts to buy gas to and from the courthouse. Okay? That's one. He's had hundreds of hours. Those podcasts, even if he requested them, are readily available to as part of the public, and he has them. I started discovering this case, and one of his plaintiffs said, because I was sending him the discovery, you're harassing me. Who are you to tell me I have 30 days to answer discovery? You're a sleazy back alley lawyer. Can the chat guess who said that? That's what his client said, because I served discovery. He had every opportunity, if he wanted discovery, to start the discovery process. But he comes here to delay this. He comes here to delay this. That's what their whole game is, to tie these two women up for no reason. And they can't make out those three standards that are mentioned in the brief. You have to look at the complaint and what was happening here. The fact is, as Mr. King said, dog was added to this. They said that the search for this missing teenager, and that, by the way, Your Honor, this is horrible to do this on the back of a missing child. It's an utter disgrace, in my opinion. But that being said, you added Bruce Castor's name. Time out. Who has the burden to satisfy on this motion? The burden to satisfy relating to the grant of immunity. Isn't that you? That's us, right?
Yes, ma'am.
Right. And so the way I read the statute and the instances where limited discovery is necessary is to help the party who's asserting the grant that they're immune, that they need discovery to establish that they're immune, that they need discovery to establish that. Is that correct? That's correct, Your Honor. Yes.
Yes, Your Honor.
This discovery is just a red herring. That's all it is. Judge, if you read this complaint, I know you got this case only recently. It's painful to read. Is it that obvious? It's hundreds. No, not really, but okay, good. But it's hundreds of paragraphs long. It is worse than reading Pride and Prejudice in the 8th grade. It is. Okay. And without doing that, and that may be one of my favorite books, but let's put that aside. So even right here, Judge is saying, like, is it obvious that this is painful? Mr. King. Well, I'm speaking for myself. Yeah, I understand. I would recommend that. But my question is pretty simple. My reading of the statute, this provision that I looked at that, said I have to do this oral argument, but could there be this discovery? But the way I read it is to allow the party who has the burden to establish immunity to get additional evidence to show why they're immune. And that's us. None of us want discovery. We don't need it, Your Honor. We don't need it. We don't want it. We don't need it. We don't want it on his face. And what I hear from Mr. Lasniak, I know you made the request for discovery. What you want discovery for is, you told me you want discovery as to the basis of their podcast. That has nothing to do with their burden to establish immunity. So I've talked through this.
But I have a burden to show probable cause that there's...
Ultimately, in your lawsuit, certainly you have a burden.
Right.
But I'm going to deny your motion for discovery. The defendants have not asked for discovery, so we can roll right into oral argument on the motion. You tell me you don't need discovery. You have the burden, right? Under what it is, A340.15. At least that's what it's saying. So let's have oral argument on your motions as to why this case ought to be dismissed, because this is all about publicly protected free speech. So who's going to argue on behalf, or is there something else? Mr. King. May it please the court, I would like to share my time with co-counsel if you don't mind. Well, I don't mind. We'll set out independently, but similar arguments for the court, if that's all right with you. Okay, so you can stand. You don't all have to stand, but so Mr. King, you and Mr. Margarian, yes, ma'am. And Mr. Stickley, you're just along for the ride? Thank you, Your Honor. All right. So I'll hear from you. You're going to start, Mr. King. Yes, ma'am. Okay, go ahead. Thank you very much, Your Honor. Defendant's motion to dismiss. First of all, I want to introduce the court to my client, our client, Barbecue, who's in the courtroom sitting behind us. Miss Barbecue is a single mom who lives near blank, Pennsylvania, in county blank, rural blank county. She is a hardworking single mom raising a child, and by means of being a wedding caterer and a dog breeder. So she breeds Frenchies, French bulldogs. In addition to that, she volunteers her time and works as a volunteer and looking for missing people, missing children. She participates in the internet in that regard. This is who Barbecue is. This is the person who's being abused, along with Granny's watching, in this particular case by these plaintiffs. Mr. Margarian will describe for you the nature of the act itself and how it applies to this particular case. But I want to say to you this. You need look no further than paragraph 65 of this terribly drawn complaint, which has no basis whatsoever in any count of this. There's not a single count in this complaint that can stand on its own. There's not a single count that's written that provides a basis for the allegations of defamation or intentional infliction of mental distress, etc. None. Or Rico. There are criminal statutes cited in this complaint. It is literally one of the worst things I've ever seen in my 50 years of practice in law. I want just to tell you that you need look no further than paragraph 65.
You good?
Sorry, 1 second.
No, you're okay.
Paragraph 6. And by the way, before I get any further, I do think it's important that we know whether Mr. Castor is actually before the court today, because all the lawyers are here. All the lawyers have entered appearances. I don't believe, and I know Mr. Castor personally, I've known him for many years. I don't believe that Mr. Castor is a lawyer in this case. So if I might, Your Honor, I would ask the court to inquire of Mr. Lasniak whether Mr. Castor is actually a lawyer in this case before we go much further, because that's part of what we brought to your attention. Is trying to use the former acting attorney general of Pennsylvania and use his name in his complaint by putting his name on the pleading. I brought this up to Mr. Lasniak in the very beginning of this case, and I said to Mr. Lasniak, listen, I know Bruce Castor. I reached out to Bruce Castor. Bruce Castor wrote back to me, and I provided that to Mr. Lasniak. And I told him that Mr. Castor said to me, I am not now, and I'm quoting, I am not now, nor will I ever be involved in this case, end quote. However, his name is used in this case on the complaint. The intent of that is to intimidate these folks. And I don't believe that Mr. Castor had a thing to do with that. So I'd like Mr. Lasniak to tell us whether Mr. Castor is a lawyer in this case or not, because he put his name on the pleading. A lawyer has a duty to be candid to the court. There are ethical requirements that lawyers have when they come before this court. But first, well, Mr. Castor's name is he's not an attorney of record. I mean, I think I hear what you're saying, that there's something in the complaint that suggests Mr. Castor is acting on behalf of the plaintiffs. But there's certainly nothing in the formal court record that identifies him as an attorney of record. His name's on the face of the complaint. And at the end of the complaint, as you know, only one counsel has to sign it, but Mr. Castor's name appears here. So I'd like Mr. Lasniak, with your indulgence, Your Honor, to tell us, is Castor part of this or not? Is he a lawyer in this case or not? He's not here. I mean, again, usually all the lawyers who are involved in the case are identified. But you know, that sometimes does fall through the cracks. Mr. Lasniak, is Mr. Castor an attorney involved in this case?
Mr. Castor was consulted, Your Honor. He represents one of the plaintiffs in another matter. He was consulted in this matter and gave permission to use his name at the top, but he has not entered his appearance. He is not an attorney of record. He has not signed any of the pleadings that we have filed with the court in any way, shape, or form. And Mr. Castor is aware of this lawsuit based off his representation of one of the plaintiffs and has been involved in consultation.
Wow, very interesting. So he was consulted, like this is just me speaking. So he was consulted in this matter and gave permission to use his name at the top, but he has not entered his appearance. He is not an attorney of record. He has not signed any of the pleadings that we have filed with the court in any way, shape, or form. Mr. Castor is aware of this lawsuit, so basically they just submitted to improper purpose. Put a 1 in the chat if you realize that is very improper.
According to Wikipedia, oh, this is a big deal. Castor's on it. Castor and their press release hold this for October 18th with this name listed as legal counsel for the plaintiffs. That's me speaking too, by the way, not in the court stuff.
They can very much get in a lot of trouble for this.
Oh,
Inaudible.
inaudible.
Yeah. Okay.
Down.
Okay, well, so he's not an attorney of record.
Nor has he ever entered his appearance, and therefore he is not sitting here.
Okay, so there you have it, Mr. King. Mr. King. Well, my point is, I'm sorry. There you have it. My point is that Mr. Castor's name was used, okay, for the purpose of intimidating these folks. Well, I wanted to direct your attention, if you would, to the complaint itself. And I don't think you have to look any further than this paragraph, although there's plenty of this stuff all throughout this complaint. It's nonsensical. It won't survive preliminary objections if we ever get to preliminary objections. But paragraph 65 of this complaint says, and is signed by Mr. Lasniak, paragraph 65 of hundreds of paragraphs in this complaint says, additionally, I experienced a particularly troubling incident when Granny's watching, defendant Jessica, stated during a live stream that she was driving to Media, Pennsylvania, with the intent to visit my office. That's an allegation of this complaint. That gives you a taste of what you're about to find when you read the rest of this complaint. This is Mr. Lasniak speaking first person in this complaint. This is why the legislator developed this particular statute, to get rid of things like this. It's clogged up the court. It's taken up your own time today. It's going to take you quite a while to read through that whole complaint and see it. But the legislator developed this particular action for this very purpose, and that is to stop this stuff. And there is no provision in this statute that allows for the amendment of this complaint to begin with. The complaint has to stand or fall on its face as it is stated currently. So I'm going to defer at this point to my co-counsel, Mr. Mergarian, and he will point out the provisions of the statute that we rely upon and why it is that we say we are immune from liability in this action. Hold on for 1 second. May I talk to you for a second, Your Honor? Oh, yeah, go ahead.
The clerk says, yeah. Can we go off the record for a second?
So this was the first time they had the court swatted on the basis that we were live streaming. The court, go back on record. Live streaming of these proceedings, I don't believe is appropriate. Mouse speaker 3. Apparently somebody called for the sheriffs down here. Did your office? I did not call for a sheriff. If anybody's live streaming these proceedings, I'm not sure that is appropriate. Mr. King, it's not only not appropriate, Your Honor, it's illegal. If somebody is in here, I would suggest that everybody in the gallery advise whether they're doing that or not. It's against the law. Mr. Marjarian, you want to read him?
Yep. If you read, it tells you all electronic recording equipment, all electronic equipment must be off.
It's illegal in Pennsylvania.
It has to be off. So if it's not off.
Does Mr. Lasniak know? Does anybody have? I don't know if there's anybody. Does Mr. Lasniak know of people? Do you know of people live streaming this? Because it's illegal. It's a crime. Do you know of people live streaming this? Mr. Lasniak?
I don't. Or Judge, I don't. I mean, I've been sitting here, Judge. Sitting and...
Right.
Making arguments. I don't know.
Well, somebody is, apparently.
Okay, who's in the courtroom? I see my intern. Michael, you're not live streaming, are you?
Oh, so that guy that was there is Lasniak's intern, Michael.
That makes sense.
Oh. Court intern. No, ma'am. All right. And then the court says something. Then Mr. Lasniak. Yeah.
I have plaintiffs, Your Honor. 2 plaintiffs that are in the courtroom. 3 plaintiffs, I'm sorry.
He didn't even know how many plaintiffs he had there. Anybody back there, Mr. Nick the Hat? I recognize you from other proceedings. Anybody back there?
Not me.
Nick. Nobody? How about over here? No,
No,
not me.
Is that Julia?
That was us.
Oh, okay.
All right. Because if it shows up that, well, we'll know, someone will know, would be a problem one way or the other. How about swearing everybody in to say that they've not live streaming? Because somebody apparently is, and it's a crime, Your Honor, to do that. I understand. And if it appears publicly, then someone can take action, reporting it to whatever authority needs to be engaged, but including to the Supreme Court. It's an absolute crime. I've been in one of these before. So let's hope, because probably not a good idea to be doing something that's unlawful. What's going on? With that being said, do you still require us down here? That's the sheriff. I don't think so. Do you have the line for the live stream that we can see where it was taken from? Somebody's doing it. I have no idea. He doesn't know. It was internal management received an anonymous. I understand. Thank you. All right. I don't need you. Sheriff says, okay, thank you very much. So again, somebody on the green team side lied, called into court and stated that we were live streaming. Ridiculous. Absolutely ridiculous.
And it's anonymous, an anonymous complaint. Imagine that.
Right. And then the sheriff says, yep, thanks. All right. Okay. All right. Before, I know you turned it over to your colleague. One thing gave me a pause about what you said. Something about the statute doesn't allow for an amendment of the complaint. Is there something in the anti-SLAPP statute that says that? I was saying earlier, standard Pennsylvania practice allows for amendments when, and you all were not in agreement when I said, Mr. Lasniak, you didn't need to ask me for permission. That was as to the complaint under the rules of civil procedure. Right. Under this statute, and Mr. Margarian is going to speak to it. Under this statute, there are two parts to the statute. One is substantive, one is procedural. The substantive went into effect when Governor Shapiro signed the act into effect. The substantive rights of immunity were vested in this plaintiff under the signature by the governor. And the procedural part of it has yet to be adopted. And so the procedural part would be rules promulgated by the Supreme Court of Pennsylvania. So, for example, one of the things that's open-ended is how this is brought to your attention. And so we brought it by virtue. We followed the way that the statute outlines it. And my co-counsel brought it a different way, but equally as correct. So there's no provision in here for amending. And think about this. Why would there not be a provision for amending? Because the very thing that this statute is supposed to do is to stop something that's so egregious and so incapable of amendment, to stop it in its tracks and not drag these poor women back in here time and time again to try to amend something that's so terribly done. And I'm not exaggerating this. I try not to do that. I try not to exaggerate. But when you have the opportunity to read this complaint, you can only have the impression, in my view, that this is an egregious action by these plaintiffs who ought to be held responsible. For example, Dog the Bounty Hunter is obviously in the complaint to try to get publicity and try to intimidate these folks. There's not a single claim in this whole complaint on Dog the Bounty Hunter's behalf. Other people, like some of the people in the courtroom, they have absolutely no standing to bring these claims. They're not. There's a father of a missing child who's one of the plaintiffs. He may be able to assert some claims, but not these claims that are brought here. All this stuff happened in Tennessee. These people are, on the face of the complaint, saying that they're plaintiffs because they work for one of these media companies or they're the agent of some media company. These people have no standing to be here in this court in Delaware County. This is an egregious attempt to intimidate people. And this court ought to take the opportunity. This is one of the first cases in the whole state on this issue. This court, respectfully, ought to take this opportunity to say, this is not going to happen here in Delaware County. We're going to stop this. So I would defer now to counsel, if you don't mind, to hear the rest. But I wanted to answer your question. I understand. I appreciate that. So there's no provision for amending. And all that amending would do is drag this on. The same thing that Mr. Lasniak tried to do this morning on discovery. It's our right to have discovery, not his. And we don't need any discovery. This complaint is so bad when you see it, there's just no basis for this complaint at all on any count. All right. Thank you. Mr. Margarian?
Your Honor,
Your Honor, just for a second, I'm going to jump in. I'm going to jump Mr. Margerian real quick with regards to the motion for leave to amend. And this piggybacks on what Mr. King was saying. Not only is this egregious, the leave to amend is brought before Your Honor with improper purpose. They state that they want to add 2 defendants. One, Stephen Fisher, who entered as a party opposer, as an intervener. Yeah, but I don't want an argument on the motion for leave to amend, but I'm not. That's not before me. I'm sorry, I kind of triggered this by asking, but Mr. King made a comment about the statute under which he's bringing this motion to dismiss, having some sort of provision that's not allowed for amendments to complaint. But what you have to look at is the totality of the filing. When they say they want to add a defendant and the plaintiff nicked the hat, texts that defendant and says, At Night Media has no intent of adding you to the suit, that's improper purpose. You added the person your motion to leave to amend and attaching that. That's an improper purpose. That's what's being shown and played out in this courtroom. And mind you, I do want to say that Miss Granny's Watching was brought into this court, into this case, based upon one plaintiff, okay, on statements that are not defamatory for the convenience of Mr. Hazafrasu and Plaintiff Lasniak. And that's the only reason. With regards to barbecue, they don't have any of this. When you look at this complaint, as Mr. King said, it's not a Rico. It's not defamation. They can't make out. Even if they did have stand-in, they can't make out. There's no particularity with regards to any of the claims. It's just a bunch of nonsense. It really is. And it doesn't meet the Rico standard. It's highly, highly offensive. Okay, Mr. Margerian, I'll hear from you.
May it please the court, Your Honor. The court says, yeah.
Yeah.
Mr. Margerian says, I want to start with the only exhibit that we attached to our moving papers. This was attached as Exhibit A to a reply, and it's a text from one of the plaintiffs, Plaintiff Mathis, to Miss Barbecue.
Sorry.
The court says, okay, hold on. I just want to make sure I'm in the right place. Mr. King chimes in. Judge, we filed a supplemental memorandum on Friday. I don't know if you got that.
I do not have that. Do you have an extra copy? Can we have it up? Yeah, please, because what I have in hand here, but wait, this is just one exhibit. That's all of it. That's all it is. Here's a copy of it. Yes, this is the brief we filed yesterday. Okay, does Mr. Lasniak have any of these? Yes, he does.
I mean, they were filed, Judge. They were filed yesterday. I didn't have a chance to. It's been a minute.
Okay, it's on the docket. Yes. You submitted it for filing. Yes, yesterday. We filed it yesterday. At some point, I'll be on the docket.
At some point, yeah. It hasn't been put on. Yeah.
There's a reply brief in there. Perfect. And that's the exhibit.
So I have not seen it, Judge.
All right. You know what? Thank you. How about you give this to Mr. Lasniak? That's the one page, right? That's the exhibit, the single exhibit, right? Exhibit A. Exhibit A, Your Honor. To the reply brief in further support of Barbecue's motion that we're having an oral argument. Okay, so I have this. And obviously I haven't looked at it either yet, Mr. Lasniak. So here it is. I just have it. You can pull yours off the docket, so go ahead. Mr. Margerian.
Well, Your Honor, I'd just like to draw your attention to it. And it just says, LOL, or quote, LOL. I'm the only one that didn't do anything to you. I'm actually going to file a civil suit against you and make you pay to defend it. Don't even care if I win. Screw filing a cease and desist. Waste of time. Stand by. I was done with you. But oh well, end quote. Now, the first sentence of that, Your Honor, after the LOL, is that it's an admission that others, including many of the plaintiffs in this case, have harmed Miss Barbecue. But setting that aside, it's the second and third sentences that reveal what is happening here today. Mr. Mathis is threatening a civil suit for the primary, if not sole, purpose to make Miss Barbecue pay to defend it. We know that's the primary purpose because he admits that he does not care whether or not he wins. This is how plaintiffs can file say that word, Granny?
Where are we?
Meritorious.
Meritorious claims.
Meritorious claims, and still obtain
That means they have no merit, claims with no merit.
fair victories. Unfortunately, more often than not, superior resources and access to attorneys willing to put their name on pleadings is enough to prevail. And prevailing in a SLAPP suit is accomplished not by winning on the merits, but by silencing your adversary. Folks who are emboldened in these SLAPP suits find out very, very quickly that we do not have free speech in this country. We have as much free speech as you can afford in attorney's fees. Your Honor, those of us who routinely represent victims of SLAPP lawsuits advocated for nearly a decade for a legislative solution to this central problem caused by these kinds of lawsuits. Finally, last summer, the governor signed into law the Uniform Public Expression Act, Protection Act, making the Commonwealth of Pennsylvania the latest state to try and curb the scourge of SLAPP lawsuits. Although the text from Plaintiff Mathis is clarifying, it's brutally honest. We don't need it to prove that this lawsuit is precisely the kind that this legislature sought to curb. The complaint itself has all the hallmarks of a SLAPP. It's 83 pages, 350 paragraphs, and 300 pages of exhibits. The complaint utterly fails to adhere to the most basic rules of pleading in the state, forcing the defendants and soon this court to wade through its nonsensical claims to decipher the nature of the allegations against the plaintiff's claims aimed at Miss Barbecue's right to free speech fail to allege of any kind. It's requisite, particularly the content of the actual statements made, despite the fact that many, if not most, of Miss Barbecue's statements, as Mr. Lesniak admitted today, are recorded. The complaint contains very few allegations, including Miss Barbecue's actual words. And when it comes to claims of defamation and the like, false light, disparagement, etc., the actual words and context are critical because the meaning is often derived from the context. A few actual quotes in the complaint attributed to Miss Barbecue amount to nothing more than insults, which are not actionable and protected by the First Amendment. The fact that the plaintiffs were insulted or annoyed or offended by Miss Barbecue words is not enough to assert claims of defamation. Same holds for sarcasm and mockery. Again, these are protected under the First Amendment. Same holds true for statements of pure opinion. The fact that Miss Barbecue expressed her opinion that the plaintiff is lazy or foul or otherwise somehow flawed is not actionable. The applicable standards are heightened in this case because it involves an issue of public concern. The plaintiffs themselves turned this into a media circus. And now some of them, or all of them, are public figures, including Dog the Bounty Hunter, a television personality, and others are, at the very least, limited purpose public figures, which means that when you are attempting to assert a claim as a public figure or a limited purpose public figure, you have nearly impossible hurdle of alleging that Miss Barbecue actually knew her statements to be false at the time that she made the statements. And there is not a single allegation in the 350 paragraphs in this complaint that say that under this act, the fatal deficiencies of the plaintiff's complaint is enough to trigger Miss Barbecue immunity. If the court requires more, there is ample additional evidence that the plaintiff's complaint meets the definition of a SLAPP. You have a media company and a television personality as the very first two named plaintiffs in this case. Even though the complaint doesn't even attempt to assert valid claims on their behalf. They are just to draw public attention. That's it. They create additional leverage. They increase the pressure against the defendants to force them to capitulate. Second of all, Your Honor, the relief sought by the plaintiffs through the request for an injunction is frankly unconstitutional. It seeks prior restraint, including preventing defendants from communicating about the plaintiffs, including communicating about them privately. I would urge you just to read the relief section of their complaint. It is just jaw-dropping. It seeks to prevent defendants from raising funds to defend themselves in this lawsuit. It seeks to force defendants to purge all content from their accounts. It seeks to force the defendants to inform their audience to stop communicating about the plaintiffs. In other words, they are seeking the permanent silence of these folks. It is the defendant's silence that is the objective. And that's why we know it's an admission that this is a SLAPP suit, permitting they want to control every bit of this public narrative that they created. And this brings us back to where I started, which is Mr. Mathis' text. He said that he would file a civil suit. He would make Miss Barbecue defend it. And he admitted that winning was not his objective, but making her pay was. Just a year ago, defendants would have been hopelessly mirrored in this lawsuit with no immediate opportunity to extract themselves from this ill-conceived, deficiently planned, and vindictively filed lawsuit. Fortunately, the legislature gave this unique power that we have here today to this court, the tools to serve justice early in this case. On behalf of Miss Barbecue, we respectfully request the court find in her favor. Excuse me just a second. And importantly, Your Honor, there's no right to amend once this motion is filed. If the court decides that we do not make out a claim for immunity after reading that complaint, then we get an immediate appeal to the Supreme Court on this issue.
Superior.
So there's no superior
Court on this issue. That's okay.
Superior Court on this issue. So there's no right to amend. The entire purpose of the statute is to be read, construed broadly, right in the very preamble of the statute. It says that it directs the courts to construe it broadly to protect public expression to the maximum degree possible. There's no right to amend. If they wanted to amend, they had since October to do so. It's too late. We're here today. And they stand to die on that complaint.
And they stand or die.
And they stand or die on that complaint. Thank you for correcting that. That would have been an interesting one. And Your Honor, respectfully, we think immunity is in order. These are hard to read.
I know. Mr. Martucci, on behalf of defendant Granny's watching. Mr. Martucci, Your Honor, I'm going to join in my co-counsel's argument and just point out a few things out to Your Honor with regards to the type of allegations that are made. Okay. In paragraph 87, state's defendant Granny's watching mocks Mr. Rogers for stating, quote, I just want a divorce so I can start again, unquote, turning this into an opportunity to paint him as someone dismissive of his responsibilities. She sarcastically thanks him for being so nice during the divorce, as if that is some type of Rico or defamation. Next, 89, they point out defendant Granny's watching persistent sarcasm goes beyond mere commentary. It is a tactic used to diminish Mr. Rogers' character and portray him as untrustworthy, echoing the sarcastic attacks frequently employed by defendant Barbecue and other members of an enterprise. Well, I'm not going to get into the enterprise yet. I haven't pled to an enterprise with regards to Rico, but those statements are not defamation. Being sarcastic is not defamation. Now, they elicit the comment that my client had made, supposedly about Mr. Rogers, as being a judge said that he was borderline abusive. Well, last night on one of these podcasts, Mr. Seth Rogers admitted that the judge said that. So what they alleged to my client, okay, that she made a statement, but they would have to show malice and falsity. Well, he proved it last night that it isn't false, okay? So it fails there. But I want to go through some of these Rico issues because this whole complaint is causes of action for federal crimes. There is no cause of action for a federal crime in a civil court. It fails. The first test, it fails. It has prolixity of procedural errors. But when we get to Rico, okay, Rico, I've emailed Mr. Lasniak a very detailed email on what Rico is, okay? So vague allegations of Rico enterprise, okay, made up of a string of participants lacking any distinct evidence and structure does not suffice. These two, they want to say that these two women are organizing a Rico because it's not. It's not. They state that Mr. Nick the Hat podcast. Oh, wait, sorry. They state in Nick the Hat's podcast or YouTube stream is always the person that knows the person that knows the person, and we can connect that back. We've got to make those allegations for particularity, especially in this Commonwealth. It doesn't pass the federal standard of notice pleading, let alone fact pleading. Now, the case that I want to cite on that is Vanden, I'll spell it, V-A-N-D-E-N, just the site. It's Vanderbrook First Common Point Mortgage. Okay, the organization has to have an existent, separate from the alleged pattern of racketeering, and that's U.S. versus Turkett. It's a Supreme Court case. I'm citing 583 of 1981. 552 U.S. what? It's 552 U.S. 576 583, 1981. You can't show you have to show that the enterprise is not simply the same person, okay? Referred to by a different name. So you have two entities, and there's a distinctiveness requirement, okay, in alleged Rico, and a distinctiveness requirement set out a case. I just don't have the site, but it set out a case called Jaguar Cars, okay? The other case that's important is Cedric Kushner, whatever. But what you have to allege here is a Rico enterprise has to be distinct from the defendant. Person alleged to have violated the Rico, and they have to show that, okay? And the enterprise has to be distinct from the alleged pattern of racketeering. When you look at this complaint, cyber stalking, harassment, there's 35 predicate acts of Rico. They haven't alleged any of the 35. They alleged, wait, I'll correct myself. They alleged some type of witness tampering. What witness? What witness? They haven't named the witness. And what case? There's a witness that these two women, these two are tampering with? The whole point was that they were going to stop with this injunction. Scare these women. This is protected speech. Scare these women. You're not. We're going to go to the judge. The judge would like to hear you. Mr. Nick the Hat even tells my client in the back, it's called Mr. Lasniak, if you don't have a lawyer. Oh, Nick the Hat even tells my client in the back, she can call Mr. Lasniak. If you don't have a lawyer, he'll get you a lawyer. It's ridiculous, absolutely ridiculous that they wanted to stop my client when these people go on these YouTubes. I'm not a YouTube person. I never was. I don't have any social media accounts. Could care less about any of this nonsense. But I'm not going to listen to this when this is over. But it's horrific. That being said, that's how they go. They go on a show, they talk about something, and they get tips and donations from people. But they wanted to stop this by this injunction. So there's a plaintiff, Brittany Nicole Jackson, that says my client called her a sleazy piece of, a lazy piece of shit. Sorry. So there's a plaintiff, Brittany Nicole Jackson, that says that my client called her a lazy piece of, okay, that's not defamation. But what an interesting point is, they never set forth with particularity when this statement was made and in what context. Even if it was defamation, which is not, because they can't make the statute of limitations hurdle any of these complaints, then she states, oh, BJ's watching. Oh, Brittany Jackson's watching. She goes on and talks about me standing with my kids in a car. What? That's not Rico. That's not Rico. They make the arguments. Then they make arguments about emotional distress. Course indulgence for a second, Your Honor, if I may. Okay, so to have a Rico, you have to have injury to a business. You have to show injury to a business or property. So is injury to a business or property a personal affront that everybody in here, the lady, Brittany Jackson, who called me a sleazy lawyer and all this kind of nonsense, they can all get together unless it injures me and my business or property, and they have to show particularity of how that was happening. There's no injury to their property here. We can tell you that right off the front of it. And business? Business? What business? Now they can make those allegations, but they claim emotional distress is their damage. Courts consistently hold that personal injury and wrongful death actions cannot provide the basis for a RICO. See Pickleton versus United Airlines. RICO plaintiffs may recover damages for harm to business and property only, but not for emotional and mental distress suffered by alleged harassment following an airline strike. Hold on 1 second. Pause and proceeding. So this is again when they have the courts swatted on the alleged basis that somebody is fucking live streaming. So here comes, we pause for a minute and the judge comes back. So
Can
this
we
was
pause
this.
for a second?
Yeah.
Can you please do me a favor and go hit the thumbs up button for Granny, please? And then can you also, if you are so inclined, can you make sure you hit up her Give, Send, Go or one of her payment apps? Because now you hear exactly what these attorneys have been doing and what they're fighting for on behalf of their clients. Thank you.
Oh, thank you so much. And thank you, Pam, to send a cash app as we were reading. So thank you. So the judge says, so this was the second time that I was advised of some sort of dissemination of what's going on, whether it was live stream or not. Apparently, someone is posting now about what is happening here in the courtroom. So what we're going to do is my court officer is going to take everybody's cell phones and not the lawyers, because you guys are officers of the court. You're making arguments to me unless you've grown third appendages and are posting while you were taking notes and everything. I don't want your phones, but everybody in the gallery, if you have a cell phone, please give it to my court officer. This is when Barbecue's attorney says, I would ask that the deputy or the county detective be called here because I believe that it's likely that a crime has occurred and that the victims are all of us. I didn't. I have never consented to my likeliness or my voice being recorded by anyone, nor is it appropriate in a courtroom. It's absolutely a crime. So I think that a crime may be committed here. And I like to put it on the record who's in this courtroom right now before they leave. And so we know who's here. But I'd like to ask you kindly have either a county detective or one of the deputies take the names and addresses of the people who are in this court in addition to checking their phones. If, well, we have the phones, right? Yes. Now here's Mr. Lasniak.
Gotcha. What I can do at their will, they can just open their phone and show me that there's nothing on their phone, pictures or videos.
See how Mr. Lasniak says, like, they can open their phones and show me? Like, again, you're not an officer of the law. Like, why do these people think they're cops?
This is weird. This is so weird. And by the way, if you see these, there's a lot of pauses and breaks and stuff in these documents. So reading it is not just as straight through as people think. But our dogs would be okay with us reading through them like this. Trust and believe. Okay, anyways.
So the one guy's name there was Paul. That must be his intern's name, Paul. My name is Paul. And then we blacked out the last name. On the one with the metal case, now court discussion from 105 to 106. We all have to write down our shit. And then here comes one of the attorneys. Miss Barbecue tells me that she took a picture prior to the proceeding beginning. That's not an offense. She took a picture of the courtroom. The judge. Okay. Just saying them. Thank you. She took one picture prior to 11:56. That's before it started. No taking pictures inside the courtroom whatsoever. Right. Before court, after court, during court. I agree with you 100%, Your Honor. You're good? I am. Sorry for the... No, I appreciate that. Your Honor, 5 more minutes. Okay. 5 more minutes, Your Honor. All right. Now, Mr. Martucci, can I go back? You can. And I just want to have everybody conscious of the time. So almost 10 after 1. Mr. Lasniak has not had an opportunity. I have another conference at 1:30. So let's wrap it up. Yeah, I'm happy if you all want to make an additional written submission to me after today in light of the time constraints. That's fine. I think I'm supposed to have oral argument. That's what we're here for. If you want to make something in addition, that's fine, within short order. Because I believe, again, under statute, there's a time period. There's a ticking clock for me to decide the issue as well. So I'd like you to finish quickly. I'm going to go as fast, but this is important, Your Honor. Mr. Martucci, yeah. With regards to their emotional distress claim, okay. So what I was citing was Rico plaintiffs may recover damages for harm to business and property only, not for emotional and mental distress suffered by alleged harassment. Following this case, emotional distress is not recoverable under Rico as a matter of law. Alleged injury to tax consultant's reputation was personal, not an injury to his business. Call someone lazy, whatever. Okay. Talking about these things, using sarcasm, not having particular allegations made to suffice how can a defendant argue a case when they don't even tell you when? He's got this plethora of information, he says. Who stood up in there? When was the statement made? Who made it? How was it made? This is all when you look at just the thing. It's all causes of action. Cyber stalking, harassment. That's not a cause of action in a civil case in this kind of law. Okay? All these claims. And they're trying to make out a Rico? They cite all the federal statutes and then they add the Pennsylvania statute without going through distinctiveness, laying out an enterprise. Distinctiveness is very important to a Rico. Okay? And the predicate acts. And what are those predicate acts? And what has to be more than 1, 2 acts? And whether it's a closed-ended or open-ended continuity. Can't be both. They play both. The complaint fails miserably. And it is it is an attack because they don't like my client. And what happened was, and this is the other point, and I'll leave you with this, Your Honor. Plaintiff Brittany Nicole Jackson in one of her podcasts stated somebody had questioned her and said, why wouldn't you just go after Jessica personally? A restraining order or one of those avenues. Why? You have thousands of dollars. Brittany says, why? You have thousands of dollars for a lawyer? This was a free lawsuit. I could shut her up. And I'm paraphrasing so that anybody doesn't take that out of context. It's a paraphrase. This is a free lawyer. So they brought her in. They used plaintiff Brittany Nicole Jackson as a useful pawn, okay, to get jurisdictions that Mr. Lasniak wasn't going to go to Barbecues County or some other area, okay, to do this. They cite cases There's one other case that I have to address, and then I'll leave you with this, Your Honor. This Floyd case. There's another case because there's cases that are cited, estate cases in here that have nothing to do with this. The courts of Belgium, and then I'm just going to find this Hoyt case that he cites because I believe this complaint was drafted. Okay, we talk about AI. It was drafted by 100% artificial and 0% intelligence in this. The Hoyt case discusses the availability of punitive damages. He mentions this about punitive damages, emotional, extreme, and outrageous conduct. It's the Pennsylvania Human Relations Act, sexual harassment, an IAED case. That's where they get that. General harassment is not a cause of action in this Commonwealth in a civil complaint. Yet they're citing a Human Relations Act statute that grants a plaintiff the right to go after sexual harassment and rose to the level of extreme and outrageous conduct. And that's Hoyt versus Angelo. They cited 720, 745, 753. I would ask this court, I would implore this court to not use the back of a missing teenager that was 15, now 16-year-old teenager, as the roast that's being pulled open in this county by these individuals because they don't like what somebody says. That's not what the First Amendment is there for. To protect people. It's protecting. You can have sarcasm. You can curse somebody out. And that plaintiff Jackson can call me a sleazy, strong-armed individual if they want because I served discovery, because I was doing my job. And I'm not going to sue her. And I'm not going to claim that these people were involved in a ring-up, a Rico. Mr. Martucci, you said a few times they cited certain cases in a complaint because they're, again, kind of looking at what I'm trying to sign here. Their injunction. Hold on. Can you wait for you're in the injunction, not before me. Okay. So what I have is the two motions. There was nothing on the docket when I got this last week. There was no response to either of the two motions. Mr. Lasniak, you didn't file a response, did you?
No, I did, Your Honor.
Oh, you did?
Last week I did file a response. I tried to file earlier. It got rejected.
No, the response was untimely, Your Honor. Okay, well, I'll accept the response, right?
Yeah.
So, but I need a copy of it. I didn't know that there was one filed.
Absolutely, Your Honor. Can you?
I'll need a response. And I have Barbecue's reply brief, which was filed yesterday, Mr. Stickley. Yes, ma'am. All right. Can you note my objection to accepting the response? I filed a memorandum of law, to suspend, to strike that under the rules of the court. They have 20 days under Pennsylvania Code, 20 days to file a response. And under the local rule of Delaware County, they have 20 days. They have to ask the court administration for an extension. They failed to do so. And they didn't ask our counsel to do so as well. Okay. So under the local rules, this is untimely and should not be accepted by this court. Okay. And again, I seem to have opened this can of worms only because you kept referring to cases that they cited. They, meaning the plaintiffs. And so I thought, I didn't see any response from them to the motions that are before me today. Okay. So apparently there is one. I'll consider whether to, consider it, give it whatever weight I think it deserves in evaluating the motions that the defendants have to burden on anyway. So with that, Mr. Lasniak, please make sure you send that in.
I have them right here.
Okay, great. And then if you have obviously a little bit of time left for a response on the oral argument on the two motions. We're almost done, guys.
Tell me if my wind gets too loud, okay? I'm sitting outside.
Okay.
Yes, Your Honor. And if the court has stated, I would be more than happy to provide. There's about 23 minutes of audio recording that I wanted the court to hear. I understand that will not happen in this time frame. So I do have the transcripts of that. And if I can send out the audio recording for the court to listen to later, that would be acceptable to the court based off the court's time frame.
Well, if you have transcripts, I digest better.
And I appreciate that. But Judge, this is in context of podcasts. So hearing this is very important because it's back and forth in these cases.
Judge, this is a hearing on the anti-SLAPP side. This is extra. This is extraordinarily outside of the complaint that's before you. I need That's why I said at the beginning, what we were hearing today is oral argument on the motion under the anti-SLAPP statute.
That's correct, Your Honor. And I believe that the complaint needs to be amended to add the exhibits. If we can add the exhibits, Judge, because that's part of it. And
Oh, I'm being told that once the motions that I'm hearing today have been filed, then there is no amending of the complaint.
there is no amending, Judge. We filed it with these exhibits, and the Office of Judicial Support, which is responsible for accepting them, would not accept them. We then tried to send it through the sheriffs, and the sheriffs would not send the thumb drive. How do we get the exhibits to counsel or to?
What about the transcripts that you say that exist?
Yeah, there are transcripts, Judge, of more immediate. There are hundreds of hours of these YouTube podcasts, Judge. Yes, we could have made hundreds of hours of transcripts. It would have been hundreds of pages. Again, it's not true evidence. I assure you. You've heard podcasts, Judge. We've all heard podcasts. There's more to it than just what's said. It's how it's said in response to back and forth. And so we're asking the court to accept these as being in the complaint. They were in the complaint. They were the exhibits that were listed in the complaint. And so we're asking the court to allow them to be heard. I know that they're important to this. Mr. King's going to stand up and say, well, we didn't get them. They didn't ask for the scope.
I'm able to speak for myself, Your Honor. Thank you.
Now they're sitting there going to use it against me and say, oh, well, we didn't.
I'm able to speak for myself. Thank you very much. But this is beyond the scope of this hearing. Yeah.
It is not, Judge, because it is.
We respectfully object.
We have to show probable cause, Judge, that there was defamatory statements, that these individuals don't get granted immunity.
We respectfully object. For the record, I'll object as well, just to piggyback.
Your Honor, there were responses filed as of yesterday on the defendant's side regarding text messages and other evidence and exhibits. Why?
I'm responding to your late reply.
Your Honor, once again.
Why are they, Mr. Lasniak, I'd like to hear from you on why the defendants, I'm looking for my notes here. Oh, here. They're upside down. Sorry. I'd like for you to tell me what the defendants are doing, hosting true crime podcasts with topics that are culled from public sources. Why that's not publicly protected free speech.
Because it goes a step further, Judge. In this case that we're dealing with of a missing child named Rogers.
Pause really quick. I want to point out here, Joseph Lasniak did not know Sebastian's name. He could not think of Sebastian's name, so then he referred to him as missing child Rogers.
That's ridiculous.
Yeah, that's why it says it that way.
I'll read it again. In this case that we're dealing with of a missing child named Rogers, he has a father named Seth Rogers, who's a deputy sheriff in Tennessee. My clients got involved, as well as Seth Rogers, plaintiff, involved in helping to find this child back in the fall. During these podcasts, Judge, they made accusations of Seth Rogers being a pedophile. My client is a deputy sheriff, and it's not going out there. And this is more than passing a note to the person next to me. This is more than disposing in a court document. These are people who have thousands of followers who are then using that information against him as my client goes into prisons in Tennessee as a deputy sheriff, being called a pedophile on YouTube, being called, names is one thing, Judge, but accusing somebody of a crime that is, I think everybody in this courtroom can agree, is atrocious. It's one step below murder. It might even be one step above murder in this case. And then accusing him, and he's the reason, he's the one that took his child, he's the one that did X, Y, and Z, and he's the one making accusations that are not factually true. It is one thing, Judge, to sit there and state, in my opinion. It's another to go out and tell people, hey, he's a pedophile. We have Miss Granny's watching saying, putting Mr. Nick the Hat probation officer's phone number up, telling people to call the.
What a fucking lie. My attorney says, he's not a deputy sheriff. Okay, Mr. Martucci, I gave you a long leash to make a lot of statements. I'm sorry, Your Honor. Mr. Lasniak has an opportunity to tell me why I shouldn't grant your motion, so I'd like to hear from him. Sorry, Your Honor.
if I may continue, Judge,
Uh-huh.
I don't know if Mr. Martucci has something else to say. I can certainly wait. The court says no, please don't. T-minus
No,
5.
yeah. No, please don't. T-minus 5 minutes.
Mr. Lesniak, it's back to me. Yes. And so, Judge, what we have are going beyond name calling and sarcasm. We have people who are exposing to thousands of viewers in these podcasts all over the world, all over the country, who are then coming back and causing damage, irreparable damage to Mr. Mathis, who is helping Seth Rogers in the finding of his, of his child. Seth Rogers, who is a grieving father, who is a single father trying to find his child and has been for almost a year. And these podcasts are getting in the way of him doing that because they are labeling him, and they have labeled him and accused him of being the offender. They've accused him of being a molester. They have.
And that's your complaint? Those are the various causes of action that you've asserted?
They are, among others, Judge. There are numerous actions within this complaint.
I want to stick with the complaint and the allegations, and what you've been describing to me, it sounds like, is what you are hoping to prove in a lawsuit. Is that right?
Well, yes, Your Honor.
No, we're not here to prove your lawsuit. We're here to hear why your lawsuit shouldn't proceed because the defendants say what they do is publicly protected free speech.
Can I insert something really quick off the record?
Yeah,
This
of
is
course.
not in the court forms, but you notice the judge says we're here to hear why your lawsuit shouldn't proceed because the defendants say what they do is publicly protected free speech.
Mm-hmm.
Notice the term lawsuit being used for anybody that's saying it's not a lawsuit. I mean, okay. Anyways, carry on.
You can't have an injunction without a lawsuit.
Yeah, but they're even. I mean,
right.
It's silly. It's silly. Anyways, and it is not.
Why not?
It is not because
it goes beyond sarcasm.
It goes well beyond sarcasm, Judge. It goes into defaming people's reputations. There's one.
But that's your lawsuit.
Right. But where's the immunity? There's no immunity in Pennsylvania for it. It is not protected in presenting knowingly false factual allegations.
Knowingly false factual allegations? What the fuck's that even mean?
Yeah, that almost stumbled me up.
Knowingly false factual allegations?
Philadelphia Newspapers Incorporated versus HEPS. A speaker is not protected if they present knowingly false factual allegations. Dun & Bradstreet's Incorporated versus Green Moss Builders. The public concern test is central to heightened speech protection. Purely private or malicious attacks aren't privileged to the same degree. And it goes on, Judge, that malicious tone supports actual malice. The
malicious tone supports malice.
Crazy.
Sorry.
No, you're good. The plaintiffs are private figures, or at least is that right? The plaintiffs are private figures, or at least we reckless disregard for the truth.
Which makes no sense because, again, the plaintiffs are public figures, but okay. But he says they're private figures, at least we reckless disregard for the truth. He meant to say the defendants.
This is so weird.
He meant to say the defendants are private fit. Yeah, I guess. I don't know.
Yeah, he got that on backwards. Well, it looks like it. So we have private figures. We have public figures as plaintiffs in this case. And then the private figures have a protection. They have a right to reputation under Pennsylvania Constitution in this case. And their reputation has been dragged through the mud. The insulting, humiliating matter. Calling somebody a repeated curse. Also sworn emotional distress claim. Calling them name after name for hours, Judge. Hours of these podcasts. We're not talking about one time saying, oh, he's a poopy head. Or, oh, he's not good. No, hours. And days after days over countless weeks that this is coming up, Your Honor. There's no protective public expression here when it does not, when it's baseless, and there's no factual allegation when we're talking about a case involving a child being possibly abducted, kidnapped, or possibly killed. We do not know. And these people are exploiting that. They're exploiting the actors involved in that. And they're going well beyond any type of immunity in this case. Did you want to add something?
No, it's just that it's bullshit, but okay. They're the ones explaining, but okay.
And even Miss Granny's Watching states in one of her podcasts that she says Quote, I said a lot of shit about Seth Rogers, but it's only one day to be a petty bitch. And
I would like to chime in here. He so grossly misquoted me here that the quote doesn't even make sense. Hear it again. I said a lot of shit about Seth Rogers, but it's only one day to be a petty bitch. That doesn't, does that make sense to any of you?
No.
That doesn't make sense. It's not even a sense. That's not what I said. I said, what I really did say is I said a lot of shit about Seth Rogers, but I never accused him of being involved in Sebastian's disappearance. But you know what? I'm going to be a petty bitch today and say, what if? That's my quote.
This is crazy.
Yep.
It carries on. Claims he's involved in the missing child of Sebastian. She states it on the record on her own podcast. She stated that Seth Rogers was involved in the abduction of his own child. You're talking about a father, Judge, who sits there and does not have his child for a year, being told that he's the accuser and that he's going out to thousands of people. How is that protected? So I can sit here and claim that these 4 attorneys are pedophiles and that they are involved in the abduction of Rogers? No, that's not immune. That's not what the state what? That's not what the state,
because that's what he's like.
Asked that the anti-SLAPP law create to allow that kind of statements that would incite people, thousands of people over their world, into negative defamation and negative reputation of my clients who are business people. Mr. Mathis runs a business. My client runs a business. And they're being told over and over again that call Mr. Nick the Hat's probation officer and complained. And they did. Thousands of calls, Judge, and emails, complaining from all over the country, complaining about whatever it is that they're saying that they should do, and that he's been in Tennessee, that he's been here. As you can see, he still sits here. So otherwise, if there is a violation, Judge, he would be in jail. There's no immunity for actions such as that. Statements that stating things and putting public opinion on podcasts is one thing. Making factual allegations against somebody with no factual facts, with no evidence whatsoever, Judge cannot be protected immunity. Otherwise, people can go around and yell fire at a crowded theater. And I know we're going way back in that case.
That's ridiculous to even compare.
I know it's going beyond, but it's the whole idea that, Judge, there's still speech that isn't protected by the First Amendment. The reason for that is because you and I, in this day and age on the internet, and a podcast, and the ability, it used to be, you would scream at the courthouse steps and maybe 10 people would hear you walking by. Now they can scream on the internet to thousands of people. And the court has to take that into consideration. Their audience is actually bigger than the Philadelphia Inquirer and other media outlets. It is international. It is all the billions of people who have the ability to hear it. And the court has to take that into consideration when they started espousing this fact. Not opinion, but facts. When you start making defamatory statements like he takes pain pills, stealing CPI. What's CPI?
I don't know.
Can I interrupt 1 second? I just want to note that and I'm not saying you're reading it slow, but if you could imagine replaying this on 4 times speed, is how fast that he was standing behind his table, dancing back and forth, shuffling a whole table full of papers while he's saying this. He only had, remember, T-minus 5 minutes. His reaction to this was crazy. So how you're reading it, he's grasping.
Well, his sentences aren't even making sense. That's why it's so hard to read, because they are not complete sentences. They are just all over the place. It is from one plaintiff to the next plaintiff. He'll be talking about one and then inserts another. It's just, this is wild.
Yeah, he doesn't make sense. What's coming up right here?
Yeah.
When you start making defamatory statements like he takes pain pills, stealing CPI, child protective services reports, disappearing, you call me, on parole, shady. What?
There are some things that may not cross the line, Judge, but I assure you that they go well beyond, and they go the line of protected speech, and they go beyond it, well beyond it. And if Your Honor takes a look at the complaint and the exhibits and the transcripts, you will see where they go on. They claim that
Julia Valenti, and then he points back to her in her fucking military gear.
is not in the military, that she does not work for the military. Miss Jules is an honorable member of the military, has been for many years. She took on her own to go and use her dog to go search for Sebastian
For
rather.
yeah.
And they claim that she is a fraud. She is not part of the military, and that damages a member of the armed services reputation. Goes beyond protected speech when you start making statements like, Judge, you better have the facts. In fact, I went on this podcast to tell them, hey, say, in my opinion, you might be protected. Did he really do this?
He did.
Yeah.
On the podcast that he denies that he went on, the one where he says, I'm not going to allow them to use their powerful platforms. Their 15 minutes are up. They deny that in my response, but yet here he is quoting it. Yeah. So it is my opinion that you're a moron.
You better have facts. In fact, I went on a podcast to tell them, hey, say, in my opinion, you might be protected. They didn't say, in my opinion. They made statements after statements. They go back and forth. One time they said that I wasn't a real lawyer. They said that, it didn't exist. I didn't
exist. Yeah.
I
One
also
time
don't like. I'm sorry to interrupt you, but the constant they. The whole social media aspect of this is not Granny and I.
Right.
And that's what he's referencing. Like, they said this, they said that. I didn't say that he wasn't a real lawyer. There might have been people saying it, but it wasn't me.
Right. No, nobody said it. What we thought is he actually running his Twitter. It was not that he wasn't a real lawyer. It was the
Right.
question of, is he running it? But if you may nonsense, I want to read this part because I think this
Okay.
is hysterical.
Go ahead.
They said that, I didn't exist. One time they were going to come to my office and make sure that I existed. Judge, I exist. I've existed for 46 years. My Irish ethnic mother will tell you that she has paid for all 46 of those years. I exist. That's where I got like I'm a real boy. Then he said, they started what we call this term doxing. I don't know if the courts heard this term. I just learned it too, because like Mr. Martucci, I'm not in this world. I learned about this world last fall when my clients came to me and I was appalled. I heard a podcast. I listened to a podcast about legal matters. I listened to podcasts about the theater. I listened to podcasts about all sorts of things. They're wonderful, wonderful tools. But every good tool in society can be used as a weapon. We've learned that. I've used to do internet crimes, Judge, as a prosecutor. And so I understand. Every tool on the internet can be used. And in this case, this tool is being used in a way that is not only defaming, but is ruining and damaging the reputation of my clients. And so therefore, there is not unity here, Judge, as there may be in other podcasts. I know the court's probably thinking the same thing I thought when they talked about podcasts. Oh, podcasts. You listen for a little bit, Judge. You should immerse yourself. Read the complaint. Immerse yourself in what these podcasts are, because they are well beyond anything that you would expect to talk about, the latest show on Broadway or the latest case that came out by the Supreme Court. The other thing is that the Pennsylvania Supreme Court hasn't promulgated any rules regarding procedural aspects of this law. They are not processing. And then the judge says, I'll have a look. That's how he sounded, though. Like, shut up. So then she goes, I'll have a look. I'll have a look at the statute. I'll have a look at the complaint, and that the defendants have told me should not proceed based on the anti-SLAPP statute. I'll have a look at
I ask that we be allowed to hand out these.
And then he waves his little thumb, whatchamacallit, envelope of thumb drives. Yeah. Briefs that I'll have a look at the briefs that you all provided to me in connection with the arguments on the 2 motions to dismiss, and I'll take it under advisement. And I guess our clock is ticking. Your Honor, I just have 30 seconds or longer. I know you've indulged us already. Yeah, I'm 5 minutes late. I have at least 2 other lawyers in another matter. You know what I mean? Yeah, each case is very important to all the litigants, right? You all are very busy lawyers. I'm a very busy judge. I wish, perhaps not, but I wish I had hundreds and hundreds of hours to listen to a recording in one of my 250 or more cases. I don't. So that's why I said I'm going to look at the complaint as it was filed. However lengthy it was, whether maybe it didn't merit all the length, I don't know, right? So I'm going to look at it. I'm going to consider the arguments, and I'm going to take it under advisement. Thank you, Your Honor. All right?
May we hand out the exhibits, Your Honor?
Which exhibits?
Exhibits for the complaint.
If they were attached to the original complaint,
they could be attached to it.
I'm not accepting any supplementation as to the existing record at this point. Okay? That's it. Your Honor, we'll send you a copy of that concludes my business, Your Honor. That brief that I mentioned and filed by the ACLU in federal court for you. Oh, that would be the Ballard Spar one? Yes, ma'am. That would be great. And if you could, when you send me that, of course, everybody make sure you send Mr. Lasniak a copy too. Of course. All right, thank you. May I be excused, Your Honor? Yes, thank you. Thank you, Your Honor. Okay, thank you. End of proceeding.
Can I insert what I think Lesniak probably sounded like at this point? This is off the record. This is not in there. But I bet he was like, holy fuck, what the fuck did I just get myself into? And what the fuck is going on here? Nick the fucking hat. I'm calling Nick. Okay, there you go.
Yeah, I'm calling Nick. Just joined this transcript court and comments. GW's defense and judge, nonsense the green team. To hear the complaint in court, barbecue went first, followed by GW. Be sure to watch the replay for a clear. Thank you, Bob. Yeah, he was still begging to hand in the exhibits, and she said, no, I'm not taking them. He had since October to place those in. He should have done it then.
I got to go back up here for a minute because where Mr. Lesniak says every tool on the internet can be used. And in this case, this tool is being used in a way that is not only defaming, but is ruining and damaging the reputation of my clients. And so therefore, there is no unity here, Judge, as there may be in other podcasts. I know the court's probably thinking the same thing I thought when you talked about podcasts. Oh, podcasts. You listen for a little bit, Judge. You should immerse yourself. Read the complaint. Immerse yourself in what these podcasts are, because they are well beyond anything that you would expect to talk about. You know, the latest show on Broadway or the latest case that came out by the Supreme Court. The other thing is the Pennsylvania Supreme Court hasn't promulgated any rules regarding the procedural aspects of this law. They are not processing. What the absolute fuck? What is he even talking about? I mean, I know what he's talking about, but he's encouraging the judge to go immerse herself in all these things. But yet he doesn't even have a valid, like a solid argument of this is what he's, this is all like
Horrible.
It's just nonsensical. Like your guys' attorneys, Mr. Martucci, he was on it. Mr. King on it. And then Lesniak's like, where am I? How did I get here? It's crazy to me.
You know what's crazy is that he says that he doesn't and didn't have social media, but then he took right to Twitter to go on social media. But he also says that he doesn't and didn't have social media, but then admits that he would watch podcasts about theaters and stuff. So like, which one is it? Do you not have, or do you?
The fact that he skips around like he does, like that, this whole thing is just embarrassing.
Well, and again, his main focus was on the basis that we allegedly called Seth Rogers the P word. That was his whole stand-in was trying to ride off the back of Seth Rogers. He couldn't remember Sebastian's name. But again, if Seth Rogers felt that way, then Seth Rogers should pursue. But the fact that they figured that they would just throw us all together and say that it's a fucking Rico, and then for him to talk about emotional distress and all of this, I can come up here at times and act like everything's fine and all that. But you've all noticed since being served with this, I don't go live every day like I used to. I haven't been able to maintain my main schedule, which has severely impacted the money I make off this, because YouTube is my quote unquote income. Half the time I'm so fucking stressed out I can't even respond to like, don't tell me about emotional distress. Like how but because you're getting commentary back on the internet. Like, and that's why my attorney pointed out in his filing, like if you are going to poke at people on the internet and be on the internet, expect it back. They decided to take this offline and accuse us of something so serious.
There you go.
It's fucking gross.
Did you hear Kyle Graney?
I did. Good morning, Kyle. I was like, wait a minute, is that a male voice? Scared me for a second.
He just rolled out of the house.
And then even like when you go to the part where he's talking about like Julia and stuff, right? Who said she's not real military? Because I've certainly never fucking said that. So who?
I didn't say it. I don't even know who she is.
Right.
That's why they say
there's it's they. That's why they point out there's no particularity. You can't do that.
Well, in stating things like Tony owns a business. What?
Right.
Yeah.
And in what way has his quote unquote business been impacted? It's unbelievable.
Well, and it's very interesting too to like see it in the transcripts about the phone stuff that they tried to make such a big deal out of, and how that all went, and then actually what the judge was saying, and you know how she was handling that situation. That's really intriguing too.
Yeah.
They try to blow that up majorly.
Which wasted like 15 minutes of our
Yeah.
right to have our argument, an oral argument heard.
Well, I mean, he first went in there asking for a continuance. He
When
wasn't
that didn't
prepared.
work. Right.
Yeah, he was not prepared. You can see that with what he's saying. I mean, his speech pattern it's not even able to be really deciphered. It is so choppy, and from one topic to the next, it's not. Yeah, it's really interesting. This is
It's just like the filing, and that's why, because he had to hurry up and find out what was in that filing and then try to argue it. And it was odd. It was odd to watch. It was like to think that, and you can go ahead and add this into your fucking little exhibits, but the idea that this man was an alleged prosecutor for 10 years just terrifies me. It terrifies me. I didn't see any professionalism.
I wouldn't hire Lesniak if he were free and the last attorney on earth.
Well, ask what happened with the last person that hired him for free. She can't even get a call back. Well, and that's the thing, right? Like, he even admits that he's not up to par with what's being said. And then to claim he just found out about social media this fall when his quote unquote team got involved in it. Bullshit. Because you were involved when Nick was being sued for what he did over social media. So why are you lying? Like, he just lied to the court several times. It's infuriating.
It's wild. It's truly wild to see all this.
And then when the judge points out, like, I haven't seen any responses to the preliminary objections, he's like, oh, we just filed them. You filed them after you were served with a court date. You filed them over 36 days late. It's unacceptable.
I guess you should have transcribed those hundreds and hundreds of hours of podcasts.
Well, even if they transcribe them, they still wouldn't find what they're looking for, because I have never, ever called Seth Rogers the P word, ever.
And that's why he doesn't want to do in my opinion, again, this is just my opinion, but he didn't want to sit there and transcribe them because he's trying to you got to hear the tone. You got to hear how because he knows that these things being said are not
malicious.
Malicious
tone is malice, according to Lesniak.
Well, and that's what he said, right? Like, he literally said, you have to hear it. It's hours and hours and hours. And it's like, no, it's not hours and hours and hours. It's you fabricating it in your heads. Anything I've ever said came from Seth Rogers himself. If you don't want that out there, you should have advised him sooner. His spokesman should have told him to shut up. But I like this part right here. I would implore this court to not use the back of a missing teenager that was 15, now 16-year-old teenager, as the roost that's being pulled open in this county by these individuals because they don't like what somebody says. That's important to remember. This is all being done on the back of a missing child who Lesniak couldn't even recall the name of, who Dog the Bounty Hunter went on national TV and called Nicholas. You really think they give a fuck about Sebastian Rogers? No, they care more about their hurt little egos. And in our latest filing, it was pointed out that Seth Rogers, despite Lesniak's, end an argument, has not been back to work. So how's it endangering him at work, even if people were out here calling him the P word?
And why? I mean, I know he is by title considered a sheriff, but the way that they try to posture that and use that bothers me.
The same way Julia tried to use her military uniform. Yeah.
Yes, absolutely. And that's apparent why she dressed as that, so he could point back and say, look.
Right.
It was all cropped.
Lisbeth's right. The they shouldn't fly. Specifically, who is they? That's what we pointed out through all of our filings too. There's no particularity to any of this. Like, how can we fight that when you're not even saying who said it, when did they say it, where did they say it? How can we argue it if you don't even reference where it was made?
Or
Because
who
it
heard
wasn't
it.
made. Right.
Or who heard it.
It's unbelievable. And then, oh, Your Honor, as you know, I worked 10 years in sex crimes. Yeah, it makes us wonder why you're involved in this one. In this case. Why are you so involved in this case? What's your position here? I don't care if you work 10 years as a prosecutor. Like, even trying to bolster himself in that aspect, too. Like, as you know, Your Honor, I worked 10 years as a prosecutor. That does even worse, because your filing is so full of fallacies that even the most... somebody like Seth, who lives in fantasy world of Dragons and Dungeons and all that crap, whatever it's called, even nobody can read through this. And what you notice, too, is prior to the hearing, the judge didn't even read the complaint. She had no idea what was even being stated in the complaint. All she had was our preliminary objections. It's a bit infuriating.
It's such a mess. Like, did she say, it's not in there, so I'm assuming she didn't give a deadline of like when she will have her decision by?
No, but she acknowledged that she is on a deadline, and it's a 60-day deadline to give her, is
Thank
it a
you.
slap or not?
That's what I was trying to follow that for sure, but I didn't know if she had said maybe something else.
Yeah, just like, by PA law, Brittany Jackson has 30 days to abide by our request for discovery and admissions, and that clock is ticky-tocking too.
Mr. Martucci handed her a verbal spanking, and she wasn't even there. She's probably should be embarrassed because if calling her a lazy, wasteful piece of shit, her quote, in her declaration and shit, that's what she said. Well, I guess she's opened up for a real big rude awakening. If that's
not only that, but Betty just went on to call Jay a wasteful piece of shit the other day. And that's something else my attorney pointed out in his latest filing. Like, oh, so I guess it's okay for them to accuse the mother and stepfather of murder and all these things. But, if we say it's defamatory.
Yeah, he did an excellent job of verbal lashing there. And I love how flustered they got Lesniak.
Oh, he was so flustered. And this is a great point here too, right? All over the world, all over the country, who are then coming back and causing damage, irreparable damage to Mr. Mathis, who was helping Seth Rogers in finding of his child. What irreparable damage? Who's coming back? Coming back to where? Like, that's the problem. Is that he's not saying it with clarity as to what the issue fucking is. So that include yours? What's the status now? We're still waiting to hear from the judge. I mean, both of our attorneys did follow-ups to this. Just the whole thing is it's a mockery off a missing child, and they have the nerve to say that, oh, we're interfering in their search efforts. Well, that's weird. What search efforts? And these podcasts are getting in the way of him doing that, because they are labeling him, and they have labeled him and accused him of being the offender. So we're getting in the way of Seth Rogers finding his son because we labeled him the offender.
I thought they said I threatened Dog the Bounty Hunter. Why didn't he write that in there?
Right. Not only that, but let's face it, two things here. As a grown man, he has the choice to listen or not. So even if I was saying he's the offender of why his son's gone, how would that prevent you from searching for him? Two, they failed to tell the courts that he himself is admittedly a fucking suspect. He's a fucking suspect. And I like here that after he says that, the judge says, and that's your complaint? Those are the various causes of action that you've asserted? like, even she's saying, like, this is it. Like, please tell me again how having a true crime podcast with opinions, sarcasm, whatever you want to call it, isn't protected speech. Because it is.
About matters of public concern.
That
There's
they themselves,
obviously concern. There's
right,
people here watching.
they themselves bragged that it's a matter of public concern. They voiced it, how much they brought this to the public. Right here, this is what my attorney said that I really liked. And it's a fact. Not only did he go at Betty very well, but the counts here to, again, seek relief under criminal statutes, which are not properly before this forum. Plaintiff Nick uses these allegations to scare these defendants into thinking they are facing criminal charges in this civil forum. No doubt these claims were brought about for the purpose of silencing opposing points of view. If one goes on social media, expect critiques and criticism. When you yourself attack people, expect attacks back. To be clear, it was plaintiff Hess Fresu that cooked up this legal scheme to bring myself into this case for jurisdictional convenience. Yet it was plaintiff Hess Fresu that doxed myself and family on X on or about September 19th. And then we exposed that they lied about the date to try to put me into this filing, into why his own parole officers put restrictions on him. And the only reason anybody knows that is because they added it. Oh, what does this mean? What do we got here? We got Seth Rogers calling somebody a chomo? Wasn't he a chomo? Is Seth Rogers, who's cried about being called a pedo, calling people chomos? That can't be. Put a 1 in the chat if you see that. Uh-oh. That wouldn't be the main plaintiff doing what he's crying about being done. Wow. Yikes. But anyway, the only reason anybody knows that of Nick's parole officer's phone number is because they themselves added it into their exhibits, which again may not have been available to the courts, but they made them available to the public via At Night's personal website. So you were placed on special conditions on September 19th. I didn't contact Lasniak until September 25th. So how was it because of me?
It's very interesting.
Yeah. So now he plays this whole, he uses At Night to act like he's not breaking, in my opinion, breaking. I mean, right here, you shall not directly, indirectly, or through third-party forums have contact with Christopher Proudfoot and his family. This includes letters, social media, and phone calls, texts of any forms of contact under any condition for any reason. There are no exceptions. Don't you think atting people on social media is contact? I guess not in their world. Unbelievable. And then the other one, again, was the 19th. It had nothing to do with me. Matter of fact, I think I'm the only asshole that stood up and said, do not contact his parole officer.
That's likely true.
I also
Yeah.
never said to contact his parole officer ever.
Yeah. Nobody said to contact them, but I certainly said don't contact them. And as for Brittany Mystery, yeah, my attorney says that here too. If she felt that she has some type of I don't know, fucking court rights against me, she should have done that. But again, they did it off the back of a missing child. They threw in all this ludicrousy about Rico. Just over it. I like when he said maybe Betty lost business perspectives by being on a $20,000 bond. And how about last night even trying to get out on the basis that we weren't served, that I wasn't served. He didn't know if I was served. Then why didn't he try again? Why haven't you tried to serve me since October? Oh, what you gotten?
Speaking of things that were said, here is a TikTok panel, and you notice Tony is in the middle on the upper hand of this. This is a screen recording. Well, it's a clip from my video. But listen to what Tony says about another content creator.
Panel.
Oh,
I'm sorry, I wasn't very clear on that.
I'll send it to KJ.
Okay. Oh, okay. No wonder.
Well, never mind.
Oh, that says it all right there.
Yeah.
If you're on there watching that, ask him how his PEDO brother's doing.
And need I remind anybody that this is not
Oh, wow.
this asking about a PEDO brother.
Oh, a PEDO brother.
Yeah.
Can you email that clip to?
Yeah, I'll send you that.
us
I'll send you
ASAP?
that video and the timestamp of where it's at. Yep, absolutely.
Thank you.
Of course.
Let's see. Where is that?
What honestly would probably be the best screen recording, screenshot, whatever you want to call it, is, which I don't know if this exists, is maybe Seth using the word, because I mean, if you've got all these, the majority of the plaintiffs coming out and using this language and then accusing other people of saying it with no proof, who has the proof of who's saying it?
There's definitely no proof of me saying it because I've never said it. Point blank, period.
I'm talking about the plaintiffs. There are all the screenshots that they put in the exhibits or whatever today. Of Dog and Betty
they
and
all say
Nick
it.
and Honk. Yeah.
Yep. So February 6th, Brittany was served with admissions. So she has 30 days to respond to those. So surely she's working on those with her attorney Lasniak to get them in.
You would hope. One would hope. Sorry, I'm emailing this really quick. There's just so many things.
So they should be March 7th. No, listen. The fact of the matter is, it was Seth himself that has come out several times now and say, I'm a suspect. Anybody else recall this? I can't be the only one that recalls Seth Rogers saying.
I heard him saying it.
Yeah.
I definitely heard him say it.
Oh, you got Betty up here saying that SF is the P word too? I haven't heard that. I don't listen to her, but I know she's accused many people of many things. And that's another thing my attorney said, like, oh, it's okay when she says something about somebody, but not when somebody she dislikes says it about her. That's defamation. Okay. Dude, this whole thing's been fucking nuts. I can't wait for it to end. Like, I will be absolutely shocked if this judge doesn't see this for what it is. It was a little disheartening to go in there knowing she didn't see the actual complaint. So she didn't really know what was going on. But hopefully after reading it, I don't imagine.
I think that the attorneys laid it out very clear.
Yeah, I can't imagine anybody reading that won't see it for what it is.
I would actually like to hear her commentary as she's reading it and going, what is this?
Yeah, like they said, and Jane Doe 422 did. Well, who the fuck is Jane Doe? What does it have to do with me?
Also, what about Uncle Taco and Michelle, whatever, Mrs. Taco, signing a signature page with nothing in there? Like, did Seth include them on there with like this false hope? This is just a thought. I don't know this to be true. with a thought that maybe Lesniak could protect those two from something. Just a thought.
I don't know. I don't know why they have on there who they have on there. It makes no damn sense to me. I'll tell you that. And then not only that, but there's no declarations from them. So and they're out here bragging to people, oh, we are plaintiffs. But look what Jay actually sent me this the other day, and I found this interesting. So we all know that Dog the Bounty Hunter likes to get involved in many cases. Well, he got himself in Gabby Petito's. Listen to what they
manhunt
say.
for Brian Laundrie nearing its 4th week, and now police in Northport, Florida say that they had Laundrie under surveillance, quote, as best as they legally could, end quote, before he vanished. They say they never spoke with him, but had eyes on him. In the meantime, famed bounty hunter Dog is continuing with his own search. However, the Daily Mail, they did some digging on Dog and what could happen if he actually does find Laundrie. For more on that, we want to get right over to Marina Morocco. I mean, that's
Let's remember when Dog claimed that he was in Florida looking for Brian Laundrie, he was actually there to celebrate his anniversary. Just like when Dog claimed that he was in Tennessee, he was actually there for his son's wedding.
I heard that Dog picked up a piece of poop out in the grass or something and put it in his pocket and wanted it to be tested to see if it was Brian Laundrie's.
I have never heard that, but it's interesting. Very interesting.
something I guess we never really thought about. I mean, can he arrest him right away? What's the deal?
Yeah, Angie. Well, Dwayne Chapman, better known as Dog the Bounty Hunter, joined the search for Brian Laundrie last month, focusing on a Florida campsite. However, if he were to find Brian Laundrie, he would not be able to arrest him or even detain him without running the risk of being charged with kidnapping. Bounty hunters in Florida, they are required to be licensed as bail agents. And according to the Daily Mail, Doug is not, nor is he licensed as a private investigator.
Oh, you hear that? Dog is not, nor was he licensed as a private investigator. I surely the private intelligence group is licensed as a private intelligence group, right?
He's just a poopy head.
A poopy head, that's right. I mean, Your Honor, it's not that they're just calling them poopy heads, it's that they're doing it for hours and hours and hours.
Meaning that there is no legal difference between Dog and any other citizen who decides to join the search. Also,
you don't say. So Dog's not as big and powerful as he wants you all to believe?
Dog is a convicted felon, which means he cannot
own
a gun.
Dog is a Betty. You sit there and talk down on felons, and yet you are working under the fucking ladder of two. Not one, but two.
Oh, and what he's a felon for is a big deal.
Oh, yeah. Very big deal.
There is no legal difference between Dog and any other citizen who decides to join the search. Also, Dog is a convicted felon, which means he cannot own a gun. He was arrested back in 1976 for his participation in a drug deal gone bad and was convicted of first-degree murder. Dog says,
holy shit, what? Dog's a murderer? Dog's a murderer?
Wow.
He was convicted of first-degree murder. I mean,
yeah.
I mean, making it up. Can't call that defamatory.
Public knowledge.
Although they would still call that defamatory, just like they said it was defamatory that I said Seth Rogers was. I said Seth Rogers himself said that he was labeled borderline abusive by the courts. They even quote me saying it and then say that I lied because no courts depict that. Well, that means Seth Rogers once again lied, not me.
Oh, it was sent over to the attorneys of the judge actually saying that to corroborate that for you, Granny.
What, that he said himself?
No, that the judge wrote that.
In the brief.
I know.
Wait, you're saying you guys found where the judge actually said that?
Yes, and the attorneys have it. We sent it over to them yesterday.
I've never even seen that. I just heard Seth say it. They claim that no judge has ever said it. Interesting.
Receipts be receding.
Just like Lesniak's hairline.
bad and was convicted of first
Oh,
degree
my
murder.
bad. You
Dog
said Receiptin. I thought you said Receiptin. Whoop, sorry.
says he is still trying to clear his name. And according to the Daily Mail, the only license that Dog currently possesses is a license to sell insurance in Hawaii. However, there is nothing illegal about Dog searching for Laundrie. The tip line that he has set up has reportedly received about 3,000 tips on Laundrie's whereabouts. And apparently Dog has been turning over things that he considers evidence back
Imagine Dog turn over things that he considers evidence.
to the FBI, Angie.
Oh, wow. So we'll see what happens. I mean, who knows? Maybe he will find him and then we'll take it from there.
But he didn't find him. He was nowhere close. He tried to look like he was looking, but he was on a whole nother little island.
Didn't he have a book that he was like pitching whenever he went down to the whole Brian Laundrie search?
I don't know, but I do know around that time, Betty sold footage she had of Dog to Nick, in which Nick never paid her the $400.
Yeah, I'm pretty sure he had a book though. And then all of a sudden he's got another book and a leather clothing line.
Oh yeah, that he came out with after he joined the search for allegedly the search for Sebastian.
So like 2 books and a clothing line.
And then Nick came out with merchandise as well.
Betty has merchandise. Yeah, they got merch.
They got merch, y'all. Can anybody send me the video again where Betty talks about Dog and Nick and how Dog lied about finding somebody that she knows without a doubt he didn't find, and how Nick is a scammer and owes her $400? Can somebody help me find that again? I believe it would be Spitfire, who does fantastic videos, but I'm not quite sure.
Let me go look and see what I can find.
Yeah, because I know I have it.
There's just so many videos to go through. Once you start looking for something, you're like, I know it's here and I know it's this. And it's like, oh.
I think it might be this one.
Granny, check your text messages.
Okay.
2022. And then we're going to speed forward to August the 15th of 2024. For me, this was hilarious. So I had to share. So let's get started.
This video is covered under Section 107 of the Copyright Act of 1976. Allowance is made for fair use for purposes such as criticism, comment, news reporting, etc.
Let's talk about this whole homewrecker nonsense from this dumbass. First and foremost, I have collaborated with many YouTubers, men and women. What I do in my personal business has absolutely nothing to do with my audience, and it sure has nothing to do with a psycho like you. In one breath, you're telling me I'm a homewrecker. With what proof? Where's the hotel receipts? Where's these infamous pictures, right? Because Dolly is selling photos of nude women, right? So
Dolly selling photos of nude women? The fuck? That might not be the one I was looking for, though, but what the hell? Huh. Selling photos of nude women.
That's what they were saying about SF and his photography business. Which, I'm not defending SF because I haven't really looked at any of his work, but it was my understanding that he's done photography for Vogue. And if anybody's ever looked at Vogue, I'm going to cut out because I'm going over a mountain, but Vogue is partial, you know?
Well, there's a difference. What he did he didn't sell photos of nude women. He drew photos of women as they were nude, which women sign up for. There's a big difference. It's a huge difference.
Yeah. I might lose service in case it disconnects me. I just wanted to let you know ahead of time. I'm just going over a mountain.
Okay. Sounds like defamation. I mean, she does a lot of. I'm looking at a lot of these are defamatory. A lot of them are defamatory, but that one where she particularly talks about Nick and Dog and how they lied. That's the one I'm looking for. I know I have it somewhere and I showed it before, but we'll just have to see if we come about it. What do you guys think, though, about the transcripts? You think the attorneys did a good job, or you think Lasniak did a good job at pleading his case? What do you think, Nonsense, by actually seeing it?
Sorry, I was over here on another. Let me go in really quick. Give me a second.
No, you're
They're
fine.
doing yard work now. Ask me that again. Sorry, I was digging in timestamps.
I said, what do you think about how they did in court now that you actually seen it?
Well, bumbling idiots. Like, I don't understand how they brought this to the court. They're the ones that brought this to the court, wanted this action, and they were totally unprepared after all these months. Like, you have 10 plaintiffs. It's a big deal. And you are that unprepared for oral arguments. I'm really confused of how they are so unaware of what's going on. It's painful to see, truly. And it's your attorneys. I can see why they were really upset with him and being like, what are you doing? What is going on here? Like, what is this? And he was like, ooh.
In the beginning, before court even started, they were out in the hallway, and Lasniak was trying to say something like, "Oh, they can't hold this hearing today without an answer to our request to amend." And our attorneys were like, "Yeah, they absolutely can." And then it led into an argument of like, "Did you even ever do a Rico? Like, do you even know? Like, this is so horrible. Do you even know what you're saying here?" And it got intense. It got intense. As you all saw by the photo that Nick and them cried about, it got intense.
Well, I can understand. The frustration had to have been just like, what? Like, you're so unprepared for this from start to finish, and what you're claiming is not accurate. Like,
especially when you literal attorneys who have done legal work. They like my attorney has actually done Rico cases, and it has to be aggravating and painful to see something like this. And by the way, there is absolute proof that the courts did label states that inappropriate parenting that may rise to the level of abuse. So there is a court document that says that about.
Yeah, that's not good.
No, it's not.
Not good at all. I'm digging for that clip you are looking for. Give me a minute. Sorry, that's why I'm muted. Oh, I think. Give me a second.
I'm just looking at this. The courts find that there may have been inappropriate parenting, but more from father who makes the rules that may rise to the level of abuse. No wonder Seth said that about himself twice now. Very interesting. And again, I can't get over the fucking exhibits of the plaintiffs themselves calling people P words. That has to be the most amazing thing I've ever seen. I mean, good old Hongy boy here. These people have no respect for little Sebastian's life. But he does. Tweeting his story like a joke. Bastards, traffickers, drug dealers, drug addicts, abusers, wife beaters, enablers, sex offenders, pedo Carl, pedo Penny, pedo Proudfoot, monsters. Wow, you should be part of a Rico. How dare you say that? Where Reagan era conservatives 1989 tried to use Rico against adult industry. That is very interesting. Wow. Said they have read all the court documents. Who's the GT? The green team said they have read all the court. The green team told you all that there were exhibits that were that they did have exhibits and they were just sealed. They lied. They did not have sealed exhibits. How many times do we have to prove that the green team is full of lies and bullshit? Honestly. I don't know. He's so unprepared, but think about it. What could he say? The filing itself doesn't even have anything to exploit and make a case out of. I can't imagine what even a good attorney could do. Your lawyer uses humor because their injunction is a joke. That's fact. This is the most attention I've ever given this guy. And then we have Dwayne. Dog calling somebody a P word. And the fact that he put a child P word. The only way to be a P word is if it's a child. Fuck, you have to add that in for man who's been accused of murder.
Do you remember if it was on her main channel, on Betty's main channel?
No, it was somebody clipped it all together, is what it really was.
Oh, you heard it on. I know it's in one of these videos right here, though.
Let me check, see if anybody emailed it. Oh, somebody sent me a video they said we need to see. Let's check this out.
I'll keep digging for this because I'm sure it's here.
Okay, we'll play this while you dig.
I found it strange that a creator got a cease and desist, and then a couple days later, a bunch of creators did too. Did she send a copy to all of them? I wouldn't know. I'm Bullhorn Betty. I'm not. I don't know.
Eileen Warnos look-alike.
Oh, I don't know what goes on. And it goes on the ins and outs of there. Like I found out just like everybody else when you started seeing the thumbnails show up on YouTube, and it's like, well, you know, I understand. These people were sullying his son's name.
Are you profiting off Sebastian's name, Betty?
I'm genuinely curious. Never mind. Hold on. I'm gonna actually take a poll. Because this way, if you're here hate watching, if you're not comfortable admitting it, whatever, I'll do it as a poll, okay? I am genuinely curious how many of you feel that they proved. Do you feel Lesniak proved his case at the SLAPP hearing? Maybe some of you do. Maybe some of you don't. I don't know. Maybe you support them. I'm curious how many of you. So I made a poll. If you didn't want to say it out loud, feel free to if you do. But I'd love to see how you feel.
And saying horrible things about him. You can't sit there and dog his father, the only one looking out, and not be dogging that boy.
Oh. The same goes for his mother and stepfather.
That 15-year-old autistic boy. You know, people are getting up to their freaking eyeballs with the bullying on these platforms.
No,
you don't control
the
somebody.
Bully.
You don't control their behavior. You don't control what they wear, what they say, how they spend their money, how they talk. If you don't like it, buzz off. It's really that simple.
It is that simple. If you don't like what I say, don't fucking listen to me. But you don't get to accuse me of Rico, you fucking nut.
Buzz off.
Yeah, fuck off.
It's your problem. It's not the effing world's.
Amen.
Cry a river, build a bridge, get the F over it.
Yeah.
You know?
Take a short walk.
This nonsense that people can just treat people like shit and have no accountability for their actions is horseshit.
Oh, the irony here.
They have dogged that man and ran his name slapped through the mud over hurt feelings. Every last one of them cocksuckers should be sued out their ass for inflicting intentionally additional distresses on that man.
So this is where this is how they came up with the whole filing. Because this is way back when. This is way before the filing. If anybody had any doubt that it was Betty and Nick that conducted this whole entire thing, here it is right here. You sit there and say, you know, anything at all, to be honest, about emotional distress. You don't even meet the fucking bare minimum to claim it. Miss Legal Beagle.
At minimum.
Let's
not get into the defamation or any other stuff or any other of the other legal claims. And if they are going to sue, go for the snake. Go for the head. And we all know who it is.
Who is it, Betty?
That would be my suggestion. Just saying. If you're going to get one, go big or go home, baby.
There you go. There you go. If you're going to get one, go big or go home, baby. Go home broke.
If Seth or Tony are watching, if you do choose to hit one of them, make sure you go big or go home. Because we know who started all this shit for you. Go grab the ringleader. That would be my suggestion.
Who's the ringleader, Bets? You and Nick? How'd that work out for you? What a piece of shit she is.
I agree. Sorry, I'm deep in trying to find like all of this.
These people are unbelievable.
They truly are.
Like, they live in a fantasy world, honest to God. They live in an absolute fantasy world where they're not accountable for anything they say. They can say whatever they want to say, but if you hurt their feelings, you now get sued and you're part of a Rico.
Yeah.
And again, never mind. I see people writing about the person in the chat. She can fuck off too.
What's wrong? Sorry, I'm not over there. You don't have to say it. I'll go look at the chat.
These people are incredible is what they are. Oh, and by the way, I saw somebody encouraging going real life on X. These people that constantly want to interfere in people's real lives and impact it by making phone calls or filing ridiculous lawsuits or any of that. Do you think they deserve their anonymity? Put a 1 in the chat if you don't think they deserve it. Put a 2 if you think, oh yeah, it's okay, they fuck with other people's real lives. Let's allow them to remain behind a fucking anonymous account. No, Jill, that's Brittany in her mud. Let's be honest.
This is annoying.
Yeah, lots of ones. They don't deserve their anonymity. I don't think they deserve it either. I think the moment you want to fuck with somebody's real life, you deserve for people to know who you really are. Okay, you're one of the accidentals. I would have thought it was Spitfire who made the video, to be honest, because she always does fantastic ones.
Mm-hmm.
But it was Betty saying what a piece of shit Nick the Hat and Dog are. How Dog claimed to have found somebody that he didn't find because her and JLR were right there. It was a man who was walking a dog that found the lady, and that Nick still owed her money, and that he's a piece of shit.
She talks about them for multiple days when they come in around the 3rd of September. That's what I'm transcripting right now and kind of looking.
Oh, okay.
She did multiple shows on them coming into the search. That's what I'm looking at. And she does have some little off things to say, but I'm trying to find.
Wow. You don't say. Betty did not like them.
Here's where she.
One was with her in her kitchen, yeah. I thought it was a like button smash. I made a mistake on the vote too. That's okay. If the judge decides not to accept Lasny exhibits, they are done. The judge did decide not to accept them.
Sorry. Over here making noise.
9 days ago in BJ. Yeah, fuck her, dude. I can't wait to countersue the shit out of her. Tennessee Green Team told all, don't worry, we have something huge. They did. They did. Around that time, and Nonsense has proved it. They all started saying, we have something in the works. We have plans. We have something that we're going to do. If they're going to take away one of our voices, we're going to take away theirs. That's what they said. This is all retaliation.
October 10th and 11th, they were bragging about, we have a plan. We have a plan.
Right. Oh, it's right around the time Julia emailed me, ironically.
I'm trying to remember. I know exactly what clip and what you're talking about. Was it True Crama maybe?
Oh, maybe. I think it was.
There's just so many.
Because there's so many people that dislike Betty.
Yeah.
And she can try as she wants. Like, even her putting in her declarations, I'm the reason she was arrested in Tennessee. Are you fucking nuts? How could I be the reason you would be arrested? Similar to what my attorney said about Nick. If he wasn't doing anything wrong, then it wouldn't have been possible for his parole to take action. And then you got 11 months ago. I don't even know what this is. Let's play it while we look. But 11 months ago, you got Betty telling the Proudfoots about themselves. But again, they can sue people.
Well, hello, my afternoon crew. Bullhorn Betty. We are talking about Sebastian Rogers and the stuff that's going on in the case. Because if you guys don't know, let me inform you, the parents right here have left. They left the area. They got in their camper. They loaded up. They took the car. We're hearing reports that the camper was never even searched. So I don't know what's going on. The Cajun Navy, I heard that Seth got injured a little bit yesterday. Seth is Sebastian's father, right?
Oh, and then we found out later that Seth stopped searching because, disability was watching him. It meant more to keep disability payments than, to search.
I found the clip too.
Yes, let's go.
I found it. It is True Crama here.
Yes, I was just on their channel. I didn't see. Oh, this is something different. Okay.
Yeah, I think this is the one you're looking for. Okay, here you go. Tell me when to pause. Just in case you guys can't read it, it says Betty goes after Trevor Lee claims Dog the Bounty Hunter lied. In this video, I show how she contradicts herself and also have some clips where she alleged in the past that Dog and his team falsely claimed to have found a murdered person's body.
Oh, that's right. This is it. Yep.
Okay, good.
Right? I have a lot of faith in the at-night intelligence agency. I have a lot of faith in Dog the Bounty Hunter as well as Nick the Hat. Look, and somebody's giving an extra $25,000. If it's coming from Nick the Hat, I don't know. That's in conjunction with. I don't trust. Listen, Nick owes me like $400 from like 2 years ago. I don't trust the man. Let's read what this Yahoo, this idiot, this unprofessional little boy is saying.
Can you pause really quick? Yep. Yeah, she's talking about Trevor Lee, but this is coming from a woman that has a green screen as her curtain. She's sitting in her bed, wearing her pajamas, with clearly not wearing a bra, has a lot of faith in that one button, and she doesn't even have her hair brushed. She has strands of it sticking up. She's going to call somebody else an unprofessional Yahoo?
Yeah.
Bless it be.
Please do not send tips or photos from this restaurant to At Night Media. It's not At Night Media. It's At Night Intelligence Agency.
Oh, we can't find that anywhere.
They're offering rewards for photos in the restaurant Sebastian Rogers ate at the day leading to his disappearance. Sounds like a reasonable request.
No, it doesn't. You're not law
enforcement.
Sounds like something law enforcement had from the first 72 hours. But carry on.
Yeah, stuff that many people do.
Jen. Go ahead.
No. I was going to say, don't you find it ironic that they're all pissed off that SF asked if the police, he released that video? And listen, I get why some people feel the way they do. I'm not, dismissing it. But don't you find it ironic that they're all like, oh, the cops had this from the beginning. That's just bullshit. Oh, da-da-da-da-da. But yet they went over the Roadhouse footage for forever?
Yeah. It's a mindfuck.
This is the group Dog the Bounty Hunter is working with. Yes.
Dog the Bounty Hunter, not little Trevor Lee. He's asking to please text his phone number and his email for coverage of this case. It sounds like he's soliciting information that should be going to law enforcement. I don't like it.
I just wanted to talk about it. You know,
and insert them becoming co-plaintiffs shortly after.
Well, she's cursing out Trevor Lee. She's cursing out Trevor Lee for the same thing she fucking said. Trevor Lee said, I don't like it. You should give it to law enforcement. She's sitting there saying, I don't like it. It should go to law enforcement.
Upsetting. And I really don't care. It's not about
This one, in case anybody's not watching, it says back in 2021, Betty and JLR were saying that Dog the Bounty Hunter falsely claimed to have found Kathleen Moore's body after she had been murdered.
Recognition, but I don't want somebody deceiving the public. And it really burns my grits that, you know, Dog the Bounty Hunter has, claimed that he and his team found Kathleen Moore's body. You know, Jonathan and I did not find her. If we had, we are raising money, as you know. I'm hoping that I can work with Chris McDonough, because it really irks me to no end, just like with Dog the Bounty Hunter with Kathleen Moore. You know, him coming in there and throwing a press conference out and making it all about him. Yet Jonathan and I were the only ones out there in the swamps looking for her. We were less than 20 feet from her. I had to give a freaking DNA sample. I don't see any of Dog or his so-called essential team that was involved in the laundry case.
The essentials, you don't say.
Doing that.
And then we just had another incident yesterday of somebody, and who was that about?
Yesterday, I don't know. Oh, Dog Bounty Hunter. Dog Bounty Hunter, when Kathleen Moore was found, Dog Bounty Hunter just claims and puts out something without any evidence. Oh, my team found Kathleen Moore. My team. And I'm like, what? We've been out there for days. We didn't see your team out there at all looking for Kathleen Moore. So I instantly contacted the Pasco County Public Information Office, Pasco County Sheriff's Information Office, and I showed his screenshot of him claiming, I said, is this true? And they said, absolutely not. It's not true.
Yeah.
Because it wasn't true. It was false. He was just making stuff up. And that's what we have to be careful about when these cases happen. These tragedies happen because these people come out of the woodwork and make false claims and just say they're people.
And we've been victim of it ourselves.
Victimized of it.
Oh,
well, there you go.
Well, there you have it.
There you have it.
Just like the plaintiffs all dogged each other. They all dogged Tony. They dogged Nick. They dogged, Dog. And now they're all co-plaintiffs.
Besties for the resties.
Yeah. For the resties of the, hopefully, payments they're going to have to pay out for wasting the court's time.
Oh, I swear. Opportunist. Betty is an opportunist. I don't think Betty did anything wrong.
Yeah, it's funny. It's so funny you say that. I actually have a video of no other than Brittany, and at the time it was Voices, and they sat up there and they dragged Betty for filth. They were calling her an opportunist, a scammer, laughing and making fun of her. Yeah,
that couldn't be, Granny. Stop lying.
I know.
Roll
It's hard
that
to believe.
Footage if you have it.
Yeah, I mean,
How many
did you see this? You may have been sleeping. I like this part. Here, Plaintiff Griffin fails in this count because there's no actual prospective contractual relationship that she lost, nor actual damages she pinpoints. These are nothing more than vague and conclusory allegations. Moreover, there's no privity in any manner between the parties. Thus, this claim fails, and it would be futile to allow amendment because Plaintiff Griffin cannot state a claim hereto upon which relief can be granted, which is the purpose of a SLAPP, right? They're not asking for money. They're not asking, oh, thank you. They're not asking for anything. They're asking for our freedom of speech. So he says, this is my attorney.
I knew it.
He says, to be clear, if one's vehicle needs a fuel pump, does one enter the auto parts store and ask for some parts instead of a fuel pump? He should have said serpentine belt. Who are the some people that distance themselves from Plaintiff Griffin because of these defendants? This vague allegation is fatally detrimental to Plaintiff Griffin's claims. Even if some people did distance themselves from Plaintiff Griffin, she has not set forth, as stated, a prospective contractual relationship that was lost. Finally, perhaps the fact Plaintiff Griffin is out on a $20,000 bond on a restraining order out of Sumner County, Tennessee, is the cause of her potentially lost vague income and prospective relationships, all of which are strictly denied for this couch detective reporter.
Oh, couch detective reporter.
He should have said bed.
He did not.
But even the fact, maybe the fact she's out on a $20,000 bond is why she doesn't have these prospective relationships anymore.
Oh, we got a competition going. Hold on. I got to get in on it.
Thank you, Lacey Ann. I appreciate that. Thank you for gifting.
Shaking the bushes. Shake, shake, shake the bushes.
Oh, I can shake the bushes too. Oh, and guess what? As a creator nonsense, can you confirm or deny that thank you so much.
You're welcome.
Can you confirm or deny that as channel owners, we have 10 free memberships we can give monthly?
Yes. When you have a non-branded YouTube account, you get automatically at the start of every month or wherever your cycle is. I don't know if it just resets every 30 days or whatever, but every month we creators get 10 free memberships to gift. They do not cost us a penny. It is not anything of that nature.
So when somebody says something such as, I just spent money, y'all, that I don't really have, but I wanted to gift y'all some memberships. That would be,
That would be blatant.
Hi, thank you. Oh, I don't want to steal the strip club saying of making it rain. Uh-oh. But seriously,
don't do the glitter snail trail.
I honestly, though, jokes aside, I do sincerely appreciate all of your support. Nonsense. I appreciate everything you have said and done.
I know people are like, we've talked about this. Like people get so, just wait. When you and Granny, no, there will never be a day. Like I said so many times, Granny could get on this app and say, nonsense is all of the expletives, every single one. And I'd say, and Granny's still not involved in Rico and racketeering. Like you guys are so caught up in things that don't actually matter. We cannot normalize this behavior of a company like At Night or whatever you want to call them, an organization of whatever public PR campaign, in my opinion, solely, to come in and start using missing children to target other people and weaponize court systems this way. We cannot stand and normalize this stuff, and I will never be a part of normalizing it. So,
well, not only that, but hey, Iva, and thank you so much, Bob H. I really appreciate that. The other thing is, this person speaks in that juvenile type of way, like, oh, wait till you guys fall out, or oh, she's not really your friend, or this and that, because that person is the one that loses relationships left and right. That person is the one that calls everybody their best friend. That person is the one that tells their audience, oh, I love y'all so much, when she doesn't. She doesn't even know you guys, let alone love you. But that person is the one that cannot keep nor maintain a relationship for a substantial period of time. So that she projects that type of insecurity out on others. Like, oh, wait till you fall out. Wait till you fall out. Yeah, okay. Like you did with 140 plus people, including recently your, several moderators.
Yeah.
Hey, Savannah.
When you know ultimately that every relationship that you form is only for the basis of what you need from that person at the time, and then when you're done using them or they've had enough of your shit, the fallout's imminent. The thing is right now, all anybody is doing is standing for the truth and the facts. We're not doing anything like bending our necks. Anybody should be standing against this. Everybody should be standing against this. We cannot normalize this behavior happening to missing children, missing children's parents, content creators, none of the things. Because according to a certain plaintiff, bashing for cash, as she calls it, is basically Rico and racketeering. Don't ask me how she got there, but she did. She made that jump.
That's amazing.
Welcome to the enterprise.
Right. In that case, a lot of them are guilty of racketeering, right? And for those that are trying to normalize this and act like this is like what the courts were meant for, well, then I hope you tread very carefully the rest of your time as a creator on YouTube, because anybody can throw any of you into any sort of litigation if they so see fit. You say one thing somebody dislikes, and this is a quote of Nick, say one thing we dislike and we'll throw you in it too. You go ahead and normalize it. I guarantee if somebody decides that they're going to go ahead and take out some type of frivolous lawsuit against you, you'll then cry about it.
Yeah. And again, for anybody that's confused, this has never been a defamation suit. This has never been a protection order. This has never been to, oh my God, she hurt my fifis. This is so far beyond all of that. She is one of 10 plaintiffs, 10 that have made allegations. And one went on the news and said, if my child is not found, you will have blood on your hands. It's
not only that, but me agreeing to not speak on Seth Rogers wasn't good enough. So don't sit there and act like I just want to attack a poor grieving father. It wasn't that. And don't you dare say that again, especially when many of you hid your videos, but we still have you in my comment section talking shit about that same quote unquote grieving father.
Yeah, it's
Mikey's
ridiculous.
mom. Hey, girlfriend. Yeah.
They're shaking the bushes. Shake, shake, shake.
Right,
Shake the bushes.
Look at that. 32 months. Seriously, it speaks for itself.
It does. It really does. It really does. And the other day, because I know it's like, people are like, oh, nonsense has to have grannies. No, it's called fucking common decency and respect. I do not want anything that I do to negatively impact what she's got going on, because again, let me repeat, filing this was as real life as somebody can possibly go. This is as real life as it gets. There's no two ways about that. So I will continue to hold myself in the mindset of, well, it's impacting her real life. I will continue to consider what she's going through because it's real fucking life. And I'm not going to do anything to harm her further. So you can F off of me, oh, trying to make sure. No, it's called common decency and respect.
Why are they acting like that's a bad thing?
Because they don't know. They don't have it. They don't.
Right.
It's all about content for them. No, this is somebody's real life.
There's been many times you come to me and said, you know, I don't want to do anything that hurts you or whatever. And I'm like, no, you're good. Like, not that I appreciate, there's nothing, you know, I appreciate you checking. But there's also been many times you just sent me a message to say, hey, are you doing okay? And that means more than anything. And the fact that these people try to, you know, I said this to you the other day, if somebody would have came to me and said, hey, you can be guaranteed X amount of people in your live stream every time you go live. But in order to have that, you have to go through allegations of interfering in a missing child's investigation. You have to go through allegations of Rico. You have to have legit, unhinged, documented, currently on parole felons that live in your neighborhood be on your back. But hey, you'll get this amount of viewerships every time you go live. I would never, and you have to pay an attorney. I would never choose this. I didn't ask for this. I didn't want this. I wasn't given a heads up. I wasn't sent a cease and desist. I wasn't sent anything to tell me this was even coming my way. So to act like, because that's what it comes down to, you pathetic people that just so badly want to be seen on the internet, to act like any type of viewership on the internet is worth what I'm going through offline, speaks more to who and what you are and where your priorities are than you're trying to make it about me. At the end of the day, there's no amount. I don't care if I was guaranteed 10,000 subs every time I go live. Fact of the matter is, there's days I can't even go live. The amount of stress this has put on me, I can come up here every so often and act like everything's okay, but they don't fucking get it because they're not going through it. So to sit there and minimize it to content, to fucking content, how dare you? Do you know what it feels like to have to look over my shoulder everywhere I go? To have to sit down and show my kids photos of what these people look like because they live in our neighborhood? To have to call all of my family members and tell them, hey, in case there's an actual press conference on Wednesday, I'm being sued for this, and then try to explain it to somebody who's not in this world and hope that they can even begin to understand what the heck you're saying? Nobody, I didn't fucking want this. I'm not becoming a millionaire off of this. I'm not seeking fame off of this. I didn't raise hundreds of thousands of dollars. I paid just as much out of pocket as I've received helping. I'm not sitting here racking up fucking money and viewership. This idea that they're trying to like just minimize it to content. Again, get a fucking grip.
Or don't. Or don't. And just
carry on the way you are. The pitch has gotten you this far, hasn't it?
I've heard the grass is really green in the other pasture. I didn't. Yeah. Who are you? What do you? You don't belong here.
Fucking cows.
Who even are you?
You know what I always say about that? If you're so much better then how come you're in the same sector? You landed in the same place on YouTube as we did, but you're so much better then. Riddle me that.
Well, again, opinions are like assholes. We all have them. Some just don't matter. Don't matter. The wind's kind of loud. Sorry, mental block.
It's aggravating. It's just like to minimize this to viewership on YouTube. It's like, are you fucking kidding me? I didn't want this. I don't want this. I never wanted this. But that doesn't mean I'm going to roll over and allow somebody like Nick to tell me what I can and cannot say on the internet. And the fact that any of you claim that you would have, oh, I would have just shut up. I would have just shut up. Well, good for you, you fucking asshole. How about you just shut up? What if I decide right now to pay my attorney extra and throw you in some frivolous litigation and cost you tons of thousands of dollars to fucking fight it and then say, hey, don't raise any money for it because then we're going to call you a scanner. Like you're damned if you do, you're damned if you don't. But it can happen to them. And I almost wish it would. Fucking, it makes me sick. It's so aggravating.
I don't wish it would, because then standing on the facts, we would defend it that nobody deserves this. But again, I get what you're saying. I totally get what you're saying.
And not only that, though, nonsense, let's be honest. For these people to act like the only reason I'm getting support is because of this, my views may have went higher because of this, and that's the backlash of what Nick and them deserve by doing this. But to act like the only reason I have support is because of this is asinine within itself.
Bullshit.
It is absolute bullshit. And I guarantee, even if it did happen to one of them, that doesn't mean you would get the support.
Yeah.
That's what the real problem comes down to. Nobody sees me. What about me? Nobody gives a fuck about you. You're not relevant then. You wouldn't be relevant after. Nobody cares.
Yeah, this whole place is such a weird when it comes to ignoring certain things because of dislike or it's just weird. It's not the real world, thankfully. I mean, should be the real world. People should just stand against things that we stand against, like frivolous filings in court while we scream that we want justice for victims and things like that. But tying up the court, further backlogs, actual victims' cases, things like that people can't quite wrap their head around.
Well, they don't put principles over personalities, and that's beyond clear. Like these people's morals only surrounded around who they like and who they dislike. That's it. They don't stand on their morals.
They're not standing never mind. I'll be nice.
No,
do you have a birthday in the chat? Did I miss that?
No, I think they always just say that they were fucking around.
Oh, okay. I was going to say.
Thank you, time traveler. When I'm stressed, I touch myself, you asshole.
Well,
right. Betty hasn't got more support just because she's in litigation. Like,
yeah,
stupid. It's stupid. And listen, and that whole argument too, like, oh, nonsense is doing this for money. Well, one, if she was, good for her. Two, she didn't change her content for money. She's not doing anything differently. Lastly, anybody who's on YouTube that's monetized is doing it for fucking money.
It's a great bonus.
Turn off your ad revenues. Why'd you ever monetize if you weren't speaking for money? Turn it off, you hypocritical pieces of shit.
They can say anything they want to about me. Nothing's changed over here. Nothing. Like, I just became really interested in this. Like we've talked about, like at first I was like, what is this even? And then I started reading through it and pulling things, and I got more interested because I'm like, wait a second, but they said this over here, and you can go through and walk it through. And they're like,
right.
But she said it doesn't matter. That's not what the claims are alleging. I don't care. Like, truly, if I give a fuck about what strangers on the internet think of me or their opinions of me, are going to try to coddle every single person's little feelings, I won't be here because there ain't going to be a day that I give a fuck about these people's opinions of me or what I stand for.
Well, especially when these
Well, they
people's
stand for
opinions
nothing.
change based on, again, who they like and who they dislike. That's it. That's all. I didn't realize it really is Miss Liverbird's birthday. How horrible of me. I'm so sorry, Miss Liverbird. Happy birthday to you. Yeah,
Happy
everyone gets paid,
birthday.
even those crying about it. They just don't get paid as much as other people, and they feel entitled to that money. Or because they don't make as much, they feel like people are scamming. Or, again, it says a lot more about the person that's saying that. Like, oh, Nonsense is only doing this for money. Okay, tell us more about what your motives are, where your concern lies.
I mean,
Again,
if I had
that's where
talents and
you're focused.
if I was still able to, like, you know, clap my cheeks or something, maybe, you know, no, I'm a psychopath because dates and times matter to me.
Well, you're a very organized psychopath, so I love that.
I mean, hey, it works for me. If being a psychopath is that organized, it works for me. I'll lace that bitch up and wear it.
Amen to that. Also, I have a moderator of the channel, a friend of mine who's been with me for years, has a family member who had a brain aneurysm, and she can imagine it's really hard. So if we can send some prayers their way, keep them in your thoughts. If you are one who believes in the power of prayers, please consider throwing some out their way. They have young children. It's a really hard time for them.
That's horrifying. I'm really sorry to whoever that is. I will keep them in my thoughts and prayers because that is, there's so many people going through so much right now. It's truly, it's heartbreaking.
Yeah, that's the other thing. Like, we're not just bouncing heads on the internet. Like,
yeah, right. We all have real lives.
The woman's name's Kristen, if you can add that into your prayers. Yeah, like, on top of this, I still have a whole life. Like, you only get to see the parts when I'm online. I spend more time offline than I do. Like, I still have to go on with my everyday life. Like, this, it's just,
You want to know what I learned yesterday?
People suck.
No, that don't get Granny and Kyle talking on the phone because they get down rabbit holes and could probably talk for hours and hours. Kyle was all, oh, did you know this? And did you know this? And did you hear this? And I'm like, oh, hell, what did I just walk into? No, he really enjoyed that because he's like, oh, somebody I can talk to about this shit.
That's when others get it.
Yeah, it was great, though.
J-Dub said, oh my God, look, J-Dub and T-Dub are here supporting G-Dub.
Hey, Clip Punk, it's so good to see you. I'm so glad you brought my fan club over here this morning. I hope you're still being a weirdo, emailing people 40 times unsolicited over your dislike of people that I don't even know anything about. But I hope
I got one of those.
The life you deserve.
I got one of those.
I don't know how many times they're going to change their name, but welcome to my fan club.
Welcome in. Welcome in. Take a seat. Don't stay long, though.
Make
Hit
sure
the
you
thumbs
hit that
up.
thumbs up.
Right, exactly. We did find it, Kimberly. Oh, Lauren, my mom had a brain aneurysm, was in a hospital for 30 days for the swelling to go down, had surgery, lived through it. Oh, what a blessing. Thank you for sharing that. I'm glad she lived through it.
That's terrible.
Yeah.
I'm going to hop off here and let you
Yeah, I'm
close
going to
up.
wrap it up, too. Thank you so much for reading through that with me.
Yeah, sorry that I was all like, it's
No,
hard
that's how he was. It worked out perfect.
Reading that stuff the first time you like, it's not even proper. It's crazy, but
I wish
to come up.
I wish I was camera ready because I would have stood up and showed you guys exactly how he was standing and like how weird he had like his fingers on the desk. I can't even, I'm going to have to take a photo to show you guys. Like, it was so bizarre. I'm like, what is this guy doing? And then he was like fumbling and dropping his papers and the sweat and the one piece of the alleged, what is that called? Toupee was like sticking up and, oh my gosh.
I would have been sitting there just watching the toupee the entire time because I'm sure as he was getting stressed out and sweating, it was slipping further and further.
And moving.
Oh, all right,
Listen,
Granny.
you would have been allowed to. Yeah, you as well. Thank you, Nonsense.
Bye.
Bye. Punk, you would have been allowed to stay except for you, we don't do self-advertisement over here, so you're now gone. But that A for effort. I mean, we did get 1.4K thumbs up. Like aliens, dude. It was weird. I do appreciate all of you being with me this morning. I appreciate you all being patient as we read through it. It would have been better if we had extra voices to each take on a character. We could have had our avatars but it was, I didn't really plan on being the one to read them, and then things changed. So it happens. But I hope you guys were able to understand it. We could still do another reading of it and have enough people to be each person. That would be cool. As you saw, the court was rudely interrupted twice on basis of a lie. My understanding is Kelly Cat admitted to being the one to fraudulently call the courthouse on the basis of a lie. As you can see, we're still not under arrest because we didn't commit any crimes that day, the day before, and I'm likely not to commit any the day after, but you never know. Yeah, and I don't know who the hell thinks Lesniak pled his case great, but we'll find out. Only the judge can decide in the end. And the end is, I believe, April 17th, around that date. Again, Brittany has 30 days to respond to my attorney's request. We'll see if she does. And yeah, you don't have to press get on camera, dear. Oh, thank you, Kimberly. Thank you guys so much. I appreciate all of you. Thank you all for your milestones today, for the super chats, the gifted memberships. Thank you to those of you that sent Venmo and PayPal and Cash App. It really all helps out so much more than you know. And thank you to the Give, Send, Go sender. I will do a video acknowledging all of you. I feel like I don't always look at that when it's done to acknowledge you the way I should, but it does mean a lot to me. What April date is Betty's? What did the filing say? The 20? I know my attorney addressed it here. April 25th. I don't know the actual date. But we'll stay in touch with that. And Revival. Oh my God. A year. That's awesome. And I really look forward to your polls. I hope you keep them going. And I really appreciate you having common sense out here and just being you. Thank you, Revival. April 2nd. You guys think she's going to get a continuance again? Thank you, Electro. I'm curious. You think Betty's going to get another continuance? The Give, Send, Go is right here. Thank you for asking. We are getting up to 60 degrees today. So I am going to go get myself together and pretend it's spring and start cleaning up and getting my garden ready to be ready. Thank you, Jess. It was good to hear transcript. Thank you, Julie's Crafton. Tennessee says 3rd and no mo. No mo continuances. Nope, no. Ooh. April, I want Granny Barbecue to get judgment in their favor like yesterday, right now. Come on, judge. Well, remember, if this judge, for whatever reason, doesn't see it as an anti-SLAPP, we then do take it up to Superior Court. So you got to throw that in my face. I should be in Miami. Shut up, Polish. Oh, thank you, Baby Boop. I didn't know that was you. Thank you so much. I'll keep that in mind. And Casual Art, I got your Cash App yesterday. Thank you. I know what the crock. I don't eat like any of it. I just like seeing it grow and taking care of it and then going out and, plucking it. Visual so Betty can sit outside the church. Oh, that would be great. I didn't even touch on their interviews. I can't believe on the 25th and the 26th that anybody was live dragging any of the parents. Like, if there was one day to keep it strictly Sebastian focused, it was that day. Both days, since we don't know, but I can't believe it's been a year. And I just pray it doesn't get to the point where it's 2 years and 3 years and it's another similar to Summer Wells. That would be devastating. Anyway, I appreciate all of you. I hope you all have a great day. If you two have nice weather, we don't fucking care. I'm just kidding. Our weather is very bipolar. Jess and I had a rift, but we didn't fall out. Grow up, dum-dum. What, is that what she's saying, T. Adams? Who cares even if we did fall out? Did she ever pay you back? Yeah, she talks her shit. She ever pay you back? No? Didn't think so. Hashtag payback T. Adams. I heard they were really bad. Anybody want to guess how much money she requested from T. Adams behind the scenes? Take a long, wild guess. Oh, Michelle. I see it now. Thank you so much. Tara, thank you. We do have a Globetrotters game this weekend. It was part of my son's Christmas gifts. I don't know if you guys are familiar with the Globetrotters, but they're like a basketball crew that does like the cool tricks and, whoa, you guys win 400. How did you ever know? All right. This kid's now playing some type of weird music. I'm going to wrap it up. I appreciate all of you. Have a good day and be safe out there. Protect your pockets. And I don't know. Watch out for 400.